Excellent. Great. Thank you.
Okay, we are live.
Excellent. Thank you very much. All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 2nd, 2022. We have 7 bills on the docket today. We'll start off with Senate Bill 266, 125. We'll then go to 145, 232, 36, 26, 261, and 265 with Senator Lee. So we'll start off with Senator Benson with Senate Bill 266. Senator Benson, I'm going to ask to unmute you here. Welcome to the committee. Good to see you. All right, hold on, let's see here. Let's get you unmuted. Senator, we can't hear you yet. Let's get your unmuted here. Let's see if we can. There you go.
I'm okay.
Excellent. Welcome.
Well, thank you so very much, Mr. Chair and members of the committee. Thank you all so much for allowing me to come before you this afternoon to testify regarding Senate Bill 266, Department of Transportation Vehicle Litter Reporting Program. I don't have to tell you all, but you already know that this issue of the problem of litter in the state of Maryland has caused heartburn all over the state. Everybody talks about the littering problem that prevails. And so this bill will establish a vehicle litter reporting program in the Department of Transportation. The Department of Transportation will be responsible for operating hotlines that will receive littering complaints from motor vehicles. Furthermore, after a complaint is reported to the hotline, the Department of Transportation will notify the vehicle's registered owner. The letter will state that the Department of Transportation hotline reported an alleged act of littering against the driver or passenger of the owner's vehicle. The adverse effects of littering, information about the cost of littered highways and how those costs affect taxpayers, informs that littering is a crime punishable by incarceration, fines, and other penalties. And lastly, states that the letter itself is not a citation. This bill will help encourage economic development in Maryland while discouraging litter in our communities. This program will positively affect the environment and help invigorate the economy of Maryland. We show pride in how our communities look and feel. This bill will establish a program that exudes the step of guiding Maryland to be the best that it could be. Thus, I respectfully urge the committee to issue a favorable report for Senate Bill 266. Thank you so very much. And I might want to add, along with this testimony, that we did talk with the Department of Transportation in Prince George's County, and it really is shameful that $3-4 million is spent picking up trash and dealing with this whole issue of litter. A couple of years ago, it was to a point where Prince George's County had to borrow money from Montgomery County in order to keep up with this problem of littering. So we're hoping that this bill, with the help of the Department of Transportation for the great state of Maryland, will help to deter people from throwing trash out the window. I don't have to tell you that this issue of littering interferes with our Chesapeake Bay, the cleanup of our Chesapeake Bay, and the overall appearance of our communities. People treat a community, a county, the way it looks. And so this problem of littering has really prevailed, not only in Prince George's County, but it's all over the state of Maryland. So I'm hoping that you all would give a favorable response to this bill. Thank you so very much.
Thank you, Senator Benson. All right. It seems so that'll conclude the testimony for Senate Bill 266. We'll turn it over to the committee for questions. I see Senator Watson has a question, and so too does Senator West. So Senator Watson, you're up.
Thank you, Mr. Chair. Thank you, Senator Benson, for this. We all recognize we have a serious litter problem, particularly in Prince George's County. My question is about the implementation. And so what this bill says to me, unless you tell me I'm incorrect, is that if I'm on the road in my vehicle and I see someone littering, I have to take it upon myself to get that person's license tag number, call the hotline and report it for them to get what in effect is a slap on the wrist. Is that correct?
Yes.
And I've actually done that before, and I've had to, and now remember, you're driving now, so you don't have your camera up like a dash cam, like a police car, videotaping everything. There's action required that causes an individual to take their eye off the road for a moment, to either jot that down, commit that license to memory, and then remember to make that phone call. I had to follow a car after I saw him throw a soda out the window. He pulled into a gas station. I was able to get it, but then I pulled off, because when you do those kinds of things, you don't know how that other motorist is going to react. And so from my perspective, there's an aspect of risk associated with this. Now, we know that our county executive recognized, a littering campaign and is dealing with illegal dumping and those types of things, and using kind of I think it's the speed monitoring cameras, those cameras around the area to try to capture those types of things. But how can you, justify for me that there wouldn't be a risk to a motorist in trying to get this information in order to report it?
Well, when I think of, I would think it does involve some kind of risk, but we have to do something in the way of discouraging people from. Now, you have to also understand that this is not something that's required. It's really enabling. It's an enabling piece of legislation. It doesn't necessarily have to be the driver that takes the tag number. It could be some individual who is in the car. It just depends on how strongly the driver or feels about keeping the state of Maryland free of litter. But it doesn't necessarily have to be the driver of the car. But also when you think of cell phones and those kinds of things that are available in cars nowadays, I would think that there is a way in which this can take place.
Sorry about that, Senator Watson. Senator Watson, are you done on the questioning? Excellent. Okay, we'll go to Senator West.
Thank you, Mr. President. This will be very brief. First of all, Senator Benson, thank you for bringing this bill to our attention. I think it is an absolute disgrace, the amount of trash that lines our roads. And it's not just in Senator Watson's area or your area, it's in my area, it's all along the Beltway, Route 97. Every time I come down to Annapolis, I look at the litter on the side of the roads and I think this is just awful. What a way for Maryland to present itself to other people as a place where the litter is not in the trash dumps, it's along our highways. It's terrible. So I love this bill. I think in response to Senator Watson, is especially if there's a second person in the car, if my wife and I are driving, I could ask my wife to take down this license number and she could quickly jot it down and then I could report later on. It's certainly not the whole answer to the problem, but it's at least it's a partial answer. So I guess I don't have a question. I just wanted to commend you, Senator Benson, for bringing the bill to us. Thanks.
The thing that also is very troubling for me is that people do not realize what happens with this trash. When it rains or when we have inclement weather that involves water, this trash goes down to the Chesapeake Bay and creates a problem for us as it pertains to taking care of our environment and our waterways. I mean, it really is, it's a problem. And when people drive through the great state of Maryland, down 95, 495, and our major highways, and they see this trash, it also sends a message to us as citizens of Prince George's County and the great state of, it's just not Prince George's County, it's all over the state of Maryland. My home is in Western Maryland, up in Hagerstown. And when I drive up 270 and I see the litter and all the problems that are going on, it's not just Prince George's County, it's all over the great state of Maryland. And people talk about it all the time. So I thought that by putting this bill in and working with the Department of Transportation, we could at least come up with some way of saying to the citizens, this is a problem. The other thing too is we have not done a good job with public relations as it pertains, and when I say public relations, as it pertains to notifying citizens how much the taxpayers have to pay for the trash that's thrown out of the windows. We have not done a good job as a state. We haven't done a good job as counties to notify our citizens, the taxpayers, how much money. A couple of years ago, we're talking about $7 million. This year, we're talking about almost $4 million just in Prince George's County. A little over $3 million in Montgomery County. The numbers add up. That's money we could use for other problems that we're having, our education of our children, the health of our citizens. I can think of many ways in which this money could be used as opposed to dealing with this big problem of litter. It is terrible.
Thank you, Senator Benson. All right, we have another question from Senator Watson.
Yeah, sorry about the second bite, Mr. Chair. Senator Benson, is it a way we can put some teeth into your bill such that subsequent violations, when they occur, are subject to some type of fine? And I know that would cause the Department of Transportation to create some kind of database, but it just seems to me, I appreciate the raising the awareness, but at this point, it's a slap on the wrist. I want to see some action taken to change behavior. Is it possible that we can put something else in place, and would the Department of Transportation be open to that without substantially increasing the fiscal note?
I would be absolutely open to that. Now, you have to remember now that this bill is in you all's hand, and if you want to add that as an amendment, I have absolutely no problem with it at all. We had talked about it. I had talked about it with the legislative assistant here in the office, my legislative administrator, and we probably would have to have a conversation with the Department of Transportation to see how we could work that. But I do agree with you 100%. We've got to come up with a way. I go down to Georgia because my family lives down there, and I go down to visit. I don't see a scrap of paper anywhere. And we were looking at their law that was put in effect, and their law is very similar to what you're talking about. So I would strongly support an amendment to this bill. That it would be wonderful, and I thank you so very much for bringing it up.
All right, thank you.
Excellent. Thank you very much, Senator Benson. I'm sure Senator Watson won't waste time getting the amendment together. Get it? Waste. All right. Anyway, all right. With that, that'll end the hearing for Senate Bill 266. Thank you very much, Senator Benson. Always a pleasure.
Well, thank you. Thank you all very, very much. And also thank you all for the work that you do. I mean, people don't understand how hard we work down here. So every once in a while, and every opportunity that I get, I just want to say thank you all for the work that you do. You just do such a wonderful job, and I thank you all so very much.
You tell them, Senator. We much appreciated. Thank you so much.
All right, dear heart. Thank you very much.
Have a good one.
All right. Thank you.
All right. See you soon.
Thank you.
All right. All right. She's always a delight. I love her. All right. We'll. She's the best. Anyway, all right. We'll go next to. I see that Senator Beidel is here. Sandy, are Senator Beidel's witnesses here?
No, we're working on getting them here right now, but Senator Kramer does have a witness here.
Excellent. All right. So we'll skip over. Awesome. Okay, great. We'll skip over to.
Okay, sorry. Can you?
I'll let Sandy, let's meet you here. All right. We will skip over to Senate Bill 145. Senator Kramer, you're up. Welcome.
Thank you, Mr. Chair. I'm working on getting myself unmuted here with your committee folks. done. Good afternoon, Mr. Chair, members of the Judicial Proceedings Committee. Ben Kramer here to introduce Senate Bill 145. And this is going to sound a little bit familiar to you all, I think, but in a slightly different context. What the bill does is that it establishes that a member of a cooperative housing corporation is responsible for the governing body's property insurance deductible up to $10,000 if the cause of any damage to or destruction of any portion of the cooperative project originates from the member's unit. After that, the expenses are a common expense. And the reason I say this may be familiar to you is that this committee did the same thing for condominium owners. And what the goal of the bill is to create parity between folks who live in condominiums under the Condominium Act and those who live under cooperative housing corporations. And quite frankly, there is no reason why we should not have parity between the unit owners in these two different types of dwellings. Now, the difference is that with a co-op, the individual purchases an interest in the corporation and becomes a shareholder. They're a member. They do not own the unit that they live in. They have an agreement with the corporation to occupy their unit as a member of the corporation. There are certain intricacies that need to be addressed because of that are not in the bill, but will be forthcoming in an amendment to the bill. I have been working very closely with the Community Association Institute, which is the sort of umbrella organization that covers these various multi-unit dwelling common ownership entities. And they have been wonderful to work with. They have also been working with the Attorney General's office to make sure the bill does not have unintended consequences. So the clarifications that are forthcoming in the amendments, number one, will provide that 51% of the members of the cooperative want to adopt this opportunity to have parity with condominium units so that they have the same cap on the deductible. The second part is that because in the cooperative, the corporation owns the unit they're living in, the corporation is responsible for much of the maintenance of the items in the unit. So the amendment will clarify that this deductible cap and the insurance is only applicable for improvements and betterments made by the member occupying the space, or if they are negligent. So let me give you a quick example. If I'm living in the co-op unit and the plumbing that feeds the bathtub, there's a pinhole in the copper line that happens over time. It wears a pinhole and it floods the 3 floors below me. It is very likely that because the corporation owns those fixtures and is responsible for their maintenance, that they will be responsible and the resident, the member, will have no responsibility for covering those costs, including deductibles. However, if I put a plug in the bathtub and start filling it and I forget about it, and now it floods over the sides of the tub, It does the exact same damage to the 3 floors below that the leak in the pipe had done. Now, the insurance that I have will cover that loss, and I'm responsible for the deductible, but it's also now the damage is capped at the $10,000 that we do provide to owners of condominium units. So the bottom line is this: we're going to have an amendment to make sure that we don't have unintended consequences with passage of this bill. And 2, that 51% of the members of any co-op want to avail themselves of the parity that we will put in place with passage of this. And my understanding is that when we get those amendments, and I'm hoping they will be completed by tomorrow, that any concerns expressed by the Attorney General's office and those that were expressed by the Community Association Institute all go away, and we have a kumbaya moment. Tomorrow, committee, I will be bringing before you a companion bill, but I don't want to complicate the issue by discussing that at the moment. And I believe there are folks here from the Community Association Institute that will also address the amendments that are forthcoming. And again, I just want to say thank you to them because they have been working very hard to make sure we don't have unintended consequences and the bill is neat and clean when it is finished. So with that, thank you, Mr. Chair.
Excellent. Thank you very much, Senator Kramer. And then we'll now turn over to your panel. We have Ms. Katzman is here, so we'll go with her next, and then we'll go to Mr. Silverman. So Ms. Katzman, you are up.
Thank you. My name is Cheryl Katzman. I am a resident of the Montgomery Mutual Cooperative here in Leisure World. There are 898 of us who are members / occupants. Thank you, Senator Kramer, for honoring my request to bring this bill forward. The bottom line on this is recently the entire Leisure World community, including the cooperative, the Montgomery Mutual Cooperative, adopted a new insurance policy, leaving the community and the members of the co-op responsible for up to their $50,000 deductible. Now, of course, the majority of this community it consists of condo associations. As such, they enjoy the benefit of the Condo Act, making them responsible for no more than the $10,000 deductible. Unfortunately, in that we do not have that kind of equity or protection, any event that would take place by virtue of a motion of the cooperative board of directors that would emanate within the members' unit, we would individually be held responsible for the entire $50,000 deductible. With the adoption of this legislation, then, as Senator Kramer has explained, we would have equity or parity the same as the condo associations do and be held for no more than the $10,000 deductible. This is urgently needed because there are people who've said if in fact they were required to come up with $50,000 because of an incident that they were deemed responsible for, they would have to proclaim bankruptcy. So this, coupled with tomorrow's bill 65, would be of great assistance to all of us here in the cooperative and certainly any others within the state. I thank you very much for your time, and I hope that you do see fit to move this forward and pass it. Thank you.
Excellent. Thank you very much, Ms. Katzman. And we'll now move on to Mr. Silverman, who I see has entered the room. Mr. Silverman, you're up. Welcome.
Oh, thank you, Mr. Chairman. I do agree with everything that Ms. Katzman said with regard to the driving forces behind the legislation. And as you pointed out, there is another bill, Senate Bill 65, which goes hand in hand with this one, that's due to be heard by this committee tomorrow. That bill would authorize a cooperative to require, with a vote of 51% of its membership, to require members to carry what I'll call an HO6 policy. That is the form of insurance policy typically issued to condo unit owners. Whether it's actually going to be an HO6 or a different form, I'll use that shorthand for the time being. And this bill would authorize a chargeback of the master policy deductible up to $10,000 to bring it into parity with the Condo Act. Our support for the legislation is, as the Community Associations Institute, is conditioned on a couple things. One, we want to make sure that the master policy retains primacy, that it is primary coverage with the exception of any improvements or betterments made to the unit, the member's personal property, and any component from which a loss may originate for which the member has primary maintenance responsibility. And the last point is important because in most cases in co-ops, it is the co-op that maintains everything and it owns everything. And indeed, the members do not have a real property ownership. They have a real property leasehold interest in the unit. They don't actually own it. It's owned by the cooperative corporation. So we want to make sure that if we're going to charge back a deductible, that the loss that triggers the deductible is related to a component for which the member has responsibility to maintain. Otherwise, how would they avoid liability if they can't even maintain the component that fails that triggers the loss? And the other point is, just very quickly, we just want to make sure that the insurance coverage itself for the member is available in the market. And to that end, I spoke this morning with Karen Strawn, and she is working with the Maryland Insurance Administration to obtain confirmation that coverage for the deductible and for the items that we discussed is available in the insurance market to members at a reasonable cost. And we're supposed to talk with the MIA tomorrow. So hopefully I should have more information by tomorrow's hearing on that point. And that will, if that coverage is reasonably available, the Attorney General will be on board with its support for the legislation as well. Thank you. And
Thank you very
much. Running slightly over.
No worries. Thank you very much, Mr. Silverman. All right. So then I think that's the last panelist for Senate Bill 145. We'll turn to the committee for questions. I see that Senator Castley has a question, and then we'll go to Senator Watson. Senator Castley.
Thank you, Mr. Chairman. And I might be just misreading this, so be patient with me. Does this say that the member whose negligent act causes serious damage, that their liability is limited to the $10,000 deductible? Is that what this says, or are they liable for the deductible plus also liable for their direct damages?
And let me answer that, Senator. Excellent question. As written, it does relate to liability. And what I've discussed with the Attorney General is we would like to offer, provided that we can obtain confirmation from MIA that the insurance coverage is out there and reasonably available, we'd like to offer amendments that get rid of the liability aspect and instead insert language which essentially creates a no-fault insurance provision similar to what we have in the Condominium Act. And the reason is that before the Condo Act was amended in 2008, we were down a rabbit hole of negligence, if you will, where we always had to determine, was the owner negligent, were they not negligent, in order to trigger the deductible. We want to get away from any determinations of negligence, because then that will beg the question, well, who determines whether they're negligent? And where's the due process to challenge that kind of a determination. Instead, to achieve parity with the Condominium Act, we want to create a no-fault provision whereby the deductible is triggered if the loss concerns a component that the member has primary maintenance responsibility for, period. If that component triggers a loss, then the deductible can be charged back. And again, provided that the insurance industry is willing to insure the member for that deductible chargeback as they are on the condo side.
Okay, so I got that, but what if I'm an owner and it's clear that my habit of playing with fire and using caustic chemicals, which I should not have been doing in my unit, has basically destroyed the apartments, the units below me, 3 on each floor, and we have serious damages, and it's all because of my violations of my agreement, my horrible gross negligence. Does this now say that my liability would simply be limited to $10,000?
You would be limited with respect to the insurance deductible to $10,000. However, the cooperative documents already contain provisions which would enable the cooperative to pursue the member for negligence or intentional, misconduct, conduct-based violations. That already exists in the cooperative's governing documents.
Okay, so it's not a limitation on liability, it's only a limitation on liability as to this insurance coverage.
That is correct. It is only a limitation of liability for the master policy deductible.
Deductible, okay. Thank you, appreciate it. Thank you, Chairman.
Excellent. Thank you very much. All right, I saw Senator Watson first, and then we'll go to Senator West. So Senator Watson, you're up.
Thank you, Mr. Chair. So, Mr. Silverman, I think I'm almost there. One question. So I have a co-op just outside my district called Village Green, and it is probably night and day difference from Leisure World. And I would probably stake my reputation on very few had $10,000 to put up to cover some type of claim. Would this eventually lead to a requirement for an individual residing in a co-op to have insurance? I guess it would be renter's insurance, but you mentioned you were going to talk about some of those things coming up. But it seems like if this bill goes into place, and I do kind of agree with Senator Cassidy, if it's determined that you were the cause of something major, why would you want to spread those costs over other residents of the co-op? So would this bill eventually lead to some kind of requirement that every resident in the co-op have individual renter's insurance?
Well, it would have to, Senator, because in order to enable the cooperative to charge back a portion of its master policy deductible, there would have to be the availability for the member to obtain insurance coverage in the market to cover that liability. And that is what Senate Bill 65 is intending to accomplish, which is the bill that's up for tomorrow's hearing. That bill actually does authorize the co-op to require its members to obtain insurance on their units.
Excellent. Thank you very much. All right, we'll go to Senator West.
Thank you, Mr. Chair. So way back when I was in law school taking real property, I remember asking, does Maryland have co-ops? And the answer is, at least in the greater Baltimore area, almost none. There were 1 or 2 or maybe 3 in the Tuscany Canterbury section of Baltimore City. So Professor Silverman, in other parts of the state, are there a lot of co-ops in Maryland?
There are not a lot of co-ops, Senator, period, in the state of Maryland. There are co-ops in Greenbelt. Greenbelt Homes is one. Village Green, as the senator pointed out just a few moments ago. In Baltimore City, there's Tuscany Lombardi and Calvert Court, as well as a couple others.
But very few.
Yes, within the community association industry, co-ops are definitely in the minority. As you know, but New York City, Manhattan
Oh,
has
yeah, you're
quite a
full.
few.
New
Has
York
quite
is
a
full
few.
of them. Right.
That is probably the greatest concentration nationwide.
Right, but Maryland is not.
Maryland has very few of the 6,200 community associations, give or take, in the state of Maryland. I would say co-ops number less than 10% of that.
Yeah, probably a lot less than 10%. So
Probably a lot less.
I remember
Leisure
dealing
World
with.
has quite a few. Leisure World does have quite a few as well.
Okay, I remember dealing with an issue very much like this a year or two ago, but I think it was in the context of condominiums.
It was the condominiums in 2020. There was legislation that raised the deductible chargeback authority from 5,000 to 10,000
Okay.
in
So is this
recognition
really just
of rising premiums in the market.
okay? So is this bill just a mirror in the co-op area of what we passed 2 years ago with respect to condominiums?
Essentially, it is, Senator. We're trying to achieve, trying to respond to the concerns that Ms. Katzman rose from Leisure World, but also to achieve parity with the Condominium Act as much as possible.
Okay, you say essentially, are there any material differences between this bill and the bill we passed 2 years ago?
The difference would be, Senator, is that in a condo situation, in almost every case, the owner is responsible for maintenance, repair, and replacement of the unit. So in a condominium, what the law says, 11.114, section 11.114 of the Act, which you dealt with 2 years ago in 2020, says if the loss originates in the unit, period, without regard to fault, then the deductible can be charged back. In the co-op sense, we can't make it as an absolute because there are many components of the unit for which the member does not have responsibility. So instead of tying it to the unit, we're tying it to components for which the member has primary maintenance responsibility.
Okay.
So a little bit narrower a field.
And those are the amendments that the committee will be receiving. Hopefully, as I at the beginning of the hearing, I said Mr. Silverman, the Attorney General's office, are working on those amendments to create that clarification.
Thank you, Senator Kramer. I came in the middle of the hearing because I was presenting a bill in the committee, so I didn't hear. That's great. That's the end of my questions. I'm satisfied. Thanks.
Thank you.
Thank you, Senator West. All right, excellent. Looking around the committee for additional questions. Seeing none, that will conclude the hearing for Senate Bill 145. Thank you, Senator Kramer, and to the panelists. We'll
Thank you
see you tomorrow. All right.
Thank you very much, Jonathan.
Excellent. All right, with that, we'll move on to, so Senator Beidel, I see you're here. Sandy, are Senator Beidel's panelists here? They are.
Yes.
All right, excellent. So we'll now go into Senate Bill 125. Senator Beidel, welcome.
Thank you very much, Senator Chair Smith. I just want to say the bill they're referring to from 2008 was my bill in the condo law. So it's nice to hear that it's working for condos. But thank you, Chair Smith, Vice Chair Wallstreicher, and members of the Judicial Proceedings Committee. Senate Bill 125 applies to non-stock and religious corporations. So we're really talking about nonprofits and religious corporations. And it's about the revival. When an annual report to the comptroller or to the SStat is missed, they lose their charter. And when that happens, they can't raise money and have to revive their charter. So what happened this year, and you'll hear from my constituent, she was serving as a new treasurer of a nonprofit high school booster group. And she was told she had to fill out 20 years of SStat forms, the annual forms. Well, she'd only been there a year. So to ask her to sign her name to 20 years of forms that she didn't know anything about was really not very workable. And the Old Mill Patriots had really only lost their charter 2 years before. So what this bill says is you really need to fill out the forms from the time your charter was forfeited or 7 years, whichever's less. And so, this bill I have worked with SStat, and of course worked with the community. And I think this is really a win-win bill. It was because of an interpretation from the Attorney General, and they see the need to make the changes. So I hope we can have a favorable report for S Bill 125. Thank you.
Excellent. Thank you very much, Senator Beidel. And we'll now switch over to your panel. Ms. Brenza.
Brianza, yes.
Brenda, how are you? Welcome.
I'm doing well, thank you. How are you? Good afternoon. As Senator Bidle said, my name is Jennifer Brianza, and I am currently the treasurer for the Old Mill High School Athletic Boosters. I had just taken over that position July 1 of 2021, and I was treasurer, I think, for about 5 minutes when I realized that they had lost their charter for failure to file a personal property return back in 2016. The prior officers had discovered the issue, but by that time it was too late. I don't think they quite understand how to fix it, but beginning in they went back and filed the 2016 return and continued filing their annual returns every year after that, not realizing that the charter had been forfeited. So I immediately filed articles of revival, and I was told I needed to file backdated personal property returns back to 1979. The 20 years that Senator Bidle was referring to was actually the years 1979 to 1999. And I was just stunned. I was 8 years old in 1979, and I didn't have a clue what anyone was doing. And the chances of my tracking down those records were pretty slim. If you're familiar with most, most school-based nonprofits or any small nonprofit, the officers tend to turn over pretty quickly, usually about every 2 years. And that's about the length of records we get. In my case, I was lucky. I actually had records back to the early 2000s, but that didn't do me any good. What was even more interesting, though, was I had a certificate of good standing from 2002, which presumably would have meant that SSTAT had received all the proper filings up until then. Otherwise, why would they have issued us a certificate of good standing? But I was still told that I needed to go back and file the returns back to 1979. And since in my other life, I'm also an attorney, and I recognized that would have been blatant fraud because I did not have any records upon which to base those filings. I contacted Senator Bidle and asked if there was anything she could do to fix this. And here we are.
Constituent service. There you go. Excellent. All right. Well, thank you very much for your testimony. Looking around the room for questions, we've got a question from Senator West.
You're on mute, Senator.
Hold on, let's get you to unmute. Let's try one more time here. There you go.
Am I unmuted now?
We can hear you.
Yes.
Okay, thanks. Thank you, Mr. Chair. So I have a question for the sponsor. Senator Bidle, why do we want to even make people go back 7 years? Number one, thank you for pointing this out. I'm a corporate lawyer, and I had never focused on this as a problem, but clearly it is a problem. And a limited number of years is ridiculous. As your witness pointed out, most people who tried to file reports dating back 20 years are going to be engaging in fraud because they're not going to know what the numbers were. But why do you want to go back 7 years? Why don't we just go back 2 or 3?
I would absolutely like to embrace that kind of amendment, Senator West. However, I think that really is a choice for SSTAT and the Attorney General. That's where the 7 years had come from, was from SSTAT. I think in most cases we're required to have 7 years of tax returns. But as Jennifer pointed out, Ms. Brianza, she pointed out, these nonprofits change all the time.
Exactly.
The treasurers, the officers, and the records aren't there. And
right.
There's no way she could go back to 1979. But if the committee wanted to amend the bill to be 3 years, I'd certainly be amenable if SSTAT could support that.
And then my next question is, it's great that you brought this bill with respect to non-stock corporations and religious corporations, but what about normal corporations? If they throw away their records after 7 years, how in the world are they going to file reports going back 20 years without committing fraud? Wouldn't it make sense to require regular corporations, which do have to keep their records for 7 years, to go back 7 years, but the nonprofits to go back less than that?
Senator, I had a business for a long time, for 38 years. And when you don't file your annual tax return as a business, and the next year when you file your taxes, you would know that you're not required that year to file one because you've forfeited your charter. So I think it's very different with a for-profit corporation versus a nonprofit that has officers changing on a regular basis.
But my experience, my experience, people just let it happen. And they don't realize it's happened because they're not thinking about it. It's not on their radar screen. And all of a sudden their charter is forfeited. Now, the problem with that is you can't file a lawsuit. Or if you do file a lawsuit, the defendant can move to dismiss the case on the grounds that you didn't have the right to file a lawsuit because your charter was forfeited. And then you got to go back and you got to revive the charter and do everything so that you can continue to pursue your lawsuit. So there are penalties associated with letting your charter be forfeited. But if the clients that kept coming to me over the years that I was practicing law that had forfeited charters generally said, I had no idea they'd been forfeited. Now, what did they do? So anyway, it's an interesting conversation. I think the committee will get into discussing this when we vote on the bill. And I hope we vote on the bill successfully.
Senator, thank you. And I would hope that we don't do anything to prevent this from applying to our non-stock and religious corporations.
No.
Because
my
it's
thought
really
is
important for these.
My thought is regular corporations ought to file 7 years worth and nonprofits ought to file maybe 2 or 3 years worth.
Thank you for that.
I don't even know if I'm allowed to say anything at this point, but I would point out that one distinction between regular corporations and the ones in this bill is that generally nonprofits like the one I'm here today representing, we don't owe any personal property tax and there are no penalties assessed against us, even if we haven't filed them, whereas that may not be true, for a regular corporation. So there would be a fiscal note attached to the bill if that were the case. And I'd certainly hate to do anything to prevent this legislation from going through.
Good point. Thank you. Thank you
very much.
Yeah.
Thank you.
Excellent. Thank you very much. We'll go over to Senator Sidnor.
Thank you. And the question is for Ms. Brienza. Just out of curiosity, how have you moved forward? Because I would suspect that in most cases, you might have an organization that just goes ahead and just creates an entirely new entity with a very similar name so that they don't have to go through all of that.
Oh, we considered doing that.
I see Senator Chris West shaking his head. Yes.
The problem is the IRS has like over a year backlog. And in order for us to do that, we'd have to apply for a new 501c3. And that would not have happened in time for us to continue raising funds. And if any of you have kids that play sports, you know how heavily the athletic programs rely on the money the boosters raise. And it would have shut us down if I hadn't pushed this forward. And we have been reinstated, by the way. So our athletic boosters are good, but we just couldn't risk having to start all over again because we had no idea when the IRS would be able to give us a new determination letter for another 501c3.
So out of curiosity then, and I'm trying to follow the timeline because you had said that there was a time period where you all filed the annual report, but then there was some time prior to. So was SDAT saying that you were still in good standing?
I know they were in good standing as of 2002 because I have a certificate of good standing from SDAT. In 2016, the then treasurer failed to file her annual report. She later discovered it and filed it in 2018. She had already filed 17. She filed it in the 2016 and 2018, and every other one thereafter was timely filed. So there wasn't any gaps as far as I was concerned. Mm-hmm. And I had the filings or copies of the filings back to 2002. And I had to assume that anything prior to 2002 had been filed because SDAT issued us that certificate. So as far as I knew, everything had been accurately filed. And once I guess, raised this issue and got to speak to some higher ups at SDAT, I was able to get the charter reinstated. But it took quite a lot. And the average soccer mom that's running these athletic associations is not going to be able to do that.
And the reinstatement or the revival of the charter happened when?
I think I got the final notice in mid-November. I think. I don't want to misstate that, but it took me a couple months.
No, I was just.
And that was only because of Senator Vital's intervention. Otherwise, I would have kept getting the robo responses from SDAT saying, file these returns. At one point, I was actually advised to turn in 20 years worth of $0 returns. And that would have been blatant fraud because I have no idea if they actually would have been zero because the laws applying to nonprofit organizations were different back in 1979 in the early 80s. I couldn't do that.
And I suspect most people, they would have just went ahead and followed the department's instructions and just went ahead and put a bunch of zeros in
And I'd have been the one attorney out of a million that, and before the attorney grievance commission, so I was not going to do that.
One other question. So was the organization, I'm assuming it did, its determination letter wasn't revoked because you were not in good standing?
No, they didn't catch up to us, and I got this fixed in time, so now we're good.
Okay, just asking out of curiosity. Thank you.
Gonna make her out herself, you know? All right. All right. Thank you very much, Senator Sidnor. Looking around the room for additional questions. Seeing none, that'll conclude the hearing for Senate Bill 125. Thank you very much, Senator Vital.
Thank you, Mr. Chairman. You all do a great
Thank
job
you.
and I appreciate the questions. Have a great day.
Excellent. Thanks, Jennifer. Thank you.
Thanks.
All right, next we'll go on to Senator Jackson with Senate Bill 232. Senator Jackson, you're up. Welcome back to your old stomping grounds.
Thank you, Mr. Chairman, members of the JPR Committee. Today I present, first of all, Senator Jackson on behalf of District 27, presenting Senate Bill 232. Senate Bill 232 is a straightforward bill that simply provides the enabling authority by the Board of Public Works to raise the salaries of Maryland's Register of Wills. Presently, the maximum salary that registers can receive is $124,500. This legislation raises that amount to $146,500. The reasoning behind the legislation is the fact that the salaries of Register of Wills has fallen behind the salaries of other similar positions within the Maryland judiciary. Presently, the Maryland court administrators and judiciary assistant administrators often earn more than local elected Register of Wills. There are also over 30 judiciary job classifications with higher top salaries than some of our Register of Wills. Additionally, similar positions are compensated at higher rates in neighboring jurisdictions, including the District of Columbia, which highest rates are like $183,000, and in Pennsylvania, $137,000. Local registers provide a myriad of services to Maryland residents, including taking in over 20,000 wills for the safekeeping of living residents, overseeing over 200 guardianships a year, and establishing 13,000 hearings each year. Because the salaries of Maryland registers have fallen behind those of their local counterparts and fellow officers of the court, this legislation simply brings these salaries better in line with those who hold similar positions. And Mr. Chairman, like our positions, the Maryland Constitution, Article 3, subsection 35 prohibits salary increases or during the term of service in the office, unless the term is greater than 4 years. So with that, Mr. Chairman, I believe I do have a panel to present today as well. I'd ask for a favorable report from the committee, and I stand for questions if necessary. Thank you.
Thank you, Senator Jackson. And we will now go on to the first panelist, which is Mr. Griffin. Mr. Griffin, you are up. I'll try to unmute you here. Let's try one more time. There you go.
All right, thank you. Thank you, Chairman Smith and Vice Chair Walt Stryker and senators of the Judiciary Committee for allowing me to speak. And I want to thank Senator Jackson for sponsoring Senate Bill 232. The Register of Wills maximum salary, $124,500, has fallen behind the salaries of other judiciary positions. Since 2018, the salaries of judiciary employees has increased a total of 16.5%, with more to come in July. The registers make less than the court administrators and less than the judiciary assistant administrators. There are now over 30 judiciary job classifications with higher top salaries than some of the registers. The Register of Wills in Maryland earn less than the Register of Wills in our neighboring jurisdictions, as Senator Jackson mentioned, including Pennsylvania and Washington, D.C. For the foregoing reasons, the Register of Wills respectfully request a salary ceiling adjustment to the maximum of $146,500, which is an increase of 17.7%. This salary increase would bring the Register of Wills into the average salary range already being earned by assistant administrators in the judiciary. The increase is in the ceiling and not the actual salary for each register, which is set by the Board of Public Works. The increase in the ceiling would not come out of the state budget, as we are self-funded through the fees and taxes that the Register of Wills collects. The increase in the salary ceiling also has the support of Maryland Comptroller Peter Francho, and the Register of Wills are under the Comptroller for our payroll and fiscal needs. For these reasons, we respectfully ask for a favorable vote on SB 232, and thank you very much.
Excellent. Thank you very much, Mr. Griffin. Now we'll move on to Ms. Lee. Ms. Lee, you're up. There you go.
Thank you, Chairman Smith and members of the committee. And thank you, Senator Jackson, for sponsoring this bill on behalf of the registers. As my colleague has said, we're under the judiciary system, but we fall under the comptroller for our fiscal needs. And we turn over approximately $58 million annually to the general fund. We do approximately 34,000 new proceedings a year, and we establish over 14,000 court hearings. And as Senator Jackson said, we receive over 22,000 wills for safekeeping for our constituents, which is a very good thing that the constituents really like. And I'll say during COVID, with the courts closed to the public, we continue to be available to the public to assist them in their time-sensitive issues. For example, if they were trying to finalize a funeral arrangement, we met them outside to give them the paperwork, or we would meet them wherever necessary to take care of their issues at the time of need. And also, as far as pleadings, we do over 700,000. So I would say, thank you for this opportunity. I can ditto everything my colleague, Mr. Griffin, said. We do everything we can to serve the citizens of our counties. Thank you for the opportunity.
Excellent. Thank you very much. And with that, that'll conclude the testimony for Senate Bill 232. We'll turn to the committee for questions. Seeing none, thank you very much, Senator Jackson, and thank you to the panelists.
Thank you, sir.
Excellent.
Thank you.
That'll conclude the hearing for Senate Bill 232. We'll now move on to Senator West with Senate Bill 36. Senator West, you're up.
Thank you, Mr. Chair. So these next two bills are rather technical bills that are sponsored by the Maryland State Bar Association's Estates and Trust section and its section on business law. So the first one, Senate Bill 36, it follows on the bill that the committee enacted last year. Last year, the General Assembly enacted Chapter 686, which allowed a will to be electronically executed or remotely witnessed. There was a companion bill last year, which dealt with the notarization of wills, Senate Bill 735. 735 passed the Senate unanimously last year, but it got lost in the House. So this year's Senate Bill 36, this bill, attempts to push last year's bill over the goal line. Several years ago, there were attempts by the state real estate section and the Estates and Trust section of the State Bar Association to deal with the need for notarizations of legal documents by notaries public who could not be physically present at the time the legal documents were signed. The real estate section agreed to reform the law relating to notaries, but the Estates and Trust section balked when it came to wills. So at the outset of the COVID situation, the Estates and Trust section realized that in a pandemic environment, the requirement that notaries be physically present at the time a will was signed was impractical. The Estates and Trust section therefore worked with the legal counsel in the governor's office to produce an executive order which would enable the execution of wills without the need for a notary to be present at the signing. The problem was that the executive order, which overrode existing law, was only operative during the pendency of the governor's underlying emergency order dealing with COVID. So when the governor rescinded the emergency order, the executive order dealing with notaries at will signings was terminated as well automatically. The underlying law of Maryland once again was operative, requiring every will signing to involve a notary public. Senate Bill 36 is an emergency bill because the Estates and Trusts section badly needs to be able to execute wills without the need for notaries to be present at the signing. That's a long explanation for the very simple fix provided by this bill. So this bill is a top priority of the State Bar Association's Estates and Trusts section, and here's what it does. Under current Maryland law, for a will to be properly executed, there needs to be two witnesses. One of the witnesses may be the supervising attorney who prepared the will and presides over the signing. In addition, there needs to be a notary. So in every case, there will be at least three people overseeing the signing, an electronic signing or a remote signing of a will. Number one, a witness, two, the supervising attorney, and three, the notary. Under Senate Bill 36, there will not be a need for a notary at the signing, but in such a situation, the supervising attorney cannot be one of the witnesses. So there'll have to be two witnesses plus the supervising attorney. So under this bill, there will still need to be three people overseeing the signing, the two witnesses and the supervising attorney, but there will no longer be the need for the presence of a notary public at the signing. In a will signing without a notary public, this bill requires the supervising attorney to prepare an attestation that will be signed by the supervising attorney as well as by the testator and both witnesses, stating that the testator signed the will in the physical or electronic presence of the witnesses and that the witnesses signed the will in the physical or electronic presence of the testator. This attestation is virtually identical to the attestation that would be provided by the notary and will substitute for the customary attestation of the notary. That's a brief explanation of the bill. I've got a couple of experts in this area from the Wills and Estates section or States and Trust section, the State Bar Association. I think Christine Hubbard's going to go first. Am I right on that? To discuss the bill in more detail.
Sure. Thank you, Senator West. Try to.
Oh, there we go. I couldn't get my mute off for a second. Thank you, Senator West. So, my name is Christine Hubbard. I am the chair-elect of the Maryland State Bar Association Estate and Trust Law section, and of course, in support of Senate Bill 36. Senate Bill 36 corrects a conflict in the law that's now preventing us from using the electronic will statute that this committee passed last session. So we are, as Senator West said, no longer able to sign electronic wills when an in-person signing is either not safe or not practical. So the problem is, in a nutshell, the electronic will statute now requires every electronic will to be notarized. However, ROLONA, the Revised Uniform Law on Notarial Acts, excludes wills from being electronically notarized. So our e-will statute requires the notary. ROLONA says wills can't be notarized. So the first thing we're looking to do is to remove that exclusion from ROLONA to allow wills to be notarized if necessary. So the next thing that we really need is to have the ability to sign a will without a notary. Never before has Maryland law required a notary for the execution of the will. And as Senator West said, we already have a Maryland licensed attorney overseeing the entire execution process. So with respect to that self-proving affidavit, which is fine, we simply want that affidavit to be signed by either the supervising attorney or a notary. We just think that layering a notary on top of the supervising attorney requirement is overly burdensome and really doesn't add any additional protections. So in a nutshell, we're just looking at two quick things with this bill. Remove that exclusion of wills from being electronically notarized from ROLONA, and two, simply allow that self-proving affidavit to be signed by the supervising attorney or the notary. We really need to be able to go back to using electronic wills as we were accustomed to doing under that executive order. It worked great. Everyone was really got accustomed to doing it. And then when it sort of got pulled out from under us, we really felt, very deprived. And our section, over 2,300 estate planning attorneys in Maryland, are really hoping for us to pass this. We ask for your support on Senate Bill 36. Thank you.
Excellent. Thank you, Ms. Hubbard. And we'll now go on to Ms. Maffaletto.
Michaela's not here, but Sarah Call is.
We'll go to Ms. Call. You're up. Thank you.
Thank you, Chair Smith, and thank you, Senator West and the members of the committee. My name is Sarah Call. I am a trust and estates attorney and also the secretary of the Estate and Trust Law section of the MSBA. Of course, I am here in support of Senate Bill 36. At the beginning of the pandemic, when it became a danger to our client's health to have two people in a room together to witness a client's execution of a will, first we got creative. We had a lot of outdoor executions in all kinds of weather, and we had clients who were signing wills in cars and other kinds of kind of different situations that we wouldn't really want to do. And then the other problem, of course, being that there were clients who still risked their health to try to get their wills signed, and other clients who simply sat on their documents and didn't get things signed when they wanted to because the barriers were too high. Then we got the emergency orders, and we were able to supervise the valid execution of a will if the parties could see each other through a screen without being physically together. And when I do executions and supervise them in person, I was able to see through the screen the process that gave me comfort that my client's wishes were being carried out. So when the emergency orders terminated, we had hoped that Section 4102 would be a permanent method to allow us to safely execute wills with the necessary protections against fraud. Unfortunately, as Chris has just testified, we have not been able to do that with the notary requirement. So we don't know what other challenges may be coming along the way or future lockdowns, and the ability to access notaries could vary among communities, especially at a time when people are most interested in trying to get their wills signed. So to be able to have a safe execution of wills in Maryland, I respectfully request that you vote favorably for Senate Bill 36. Thank you.
Excellent. Thank you very much for your testimony. And with that, that'll conclude the testimony for Senate Bill 36 rather. I'll turn it over to the committee for questions. Senator Castley has a question.
Thank you, Mr. Chairman. So I'm just gonna, you're really blunt on this one because it should be a simple bill. Under the old system, we didn't need no notaries. It was the testator signed and two witnesses. Boom, that's how we've always done will. Two witnesses had to be in the room. So, and that's how to make sure that this is actually the person's will. Will fraud is a real and serious problem. I mean, I'm a litigator, I do those cases. It's not a made up problem. People intimidate grandma, grandpa. It's a very common thing. There's a huge incentive to manipulate grandma or grandpa to get the estate. Old people are very vulnerable to that. So will fraud is not a small matter. This is a serious stuff. So now we have to look and say, what does this do? So the part of this bill that talks about the supervising attorney or the notary, to me, is like, who cares? The issue here that really we haven't been mentioning is that those witnesses, the two witnesses to the will, need not be physically present. So as someone who has been forced to do litigation via electronics over the last year, I have felt very frustrated and constrained as a litigator because it is very difficult to judge credibility. You feel very uncomfortable that the witness is actually being coached, that you can't see that. You can't prove they're reading from a script, but you feel pretty confident there's a script in front of them, and that it's not all that it appears to be. I find great comfort in these proceedings, knowing that in the will contest, knowing that I can go bring in the two people who were literally in the room with the testator at the time they signed it, and I can inquire of them who else was there, what was happening, how long were you there, what did they look comfortable, did they look pale, did they look like they had enough sleep, did you say hello, did they say hello to you, were they kind of lying there sort of lethargically, all things that I cannot see in the video that I'm forced to use as a litigator. So I have to tell you, I'm really troubled on this. I got you. At some point, the desire for expediency in dealing with this stuff is real nice. But we constantly in this committee, we get people want to short circuit due process because it's more convenient. Yeah, it's due process is a bugger. It can be such a waste of time, such a pain in the butt. But there's a reason for it because it protects people. And the same thing with these requirements for a will. So maybe I'll just sit back and let you all, if you can respond, because I'm actually really concerned on this because I have been involved in will contests. I've seen will fraud, and this is not just, and we hear constant, we've had a number of testimony over the years from the Attorney General's office talking about manipulation of elderly folks. I've seen that it's definitely not something that requires a rocket science to do, and that there's a huge incentive to do that. I mean, a lot of these old folks are sitting on estates worth $500,000, and they weren't like high-end people. These were just average grandma and granddad who were frugal with their money and didn't spend it. And you're like, wow, big estate. So maybe you can respond. Why should I not feel very uncomfortable that we're opening ourselves up to decades of will fraud? Thank you.
We'll go to Ms. Hubbard first, and then Ms. Call if you want to chime in.
Sure. Senator Casserly, you make some extremely valid, important points. These are all the hard questions and issues that we grappled with for a couple of years as we were trying to formulate, whether we should do electronic wills. We said, no, it's not right. The timing is not right. But when the pandemic came, we figured out how can we do this? Having the ability to actually execute a will when you can't do it safely is critical. So we spent a tremendous amount of time and resources to try and figure out how we could do it safely. It's not ever going to be perfect, nor will an in-person be perfect. But we have the entire execution process being overseen by a Maryland licensed attorney. And typically it will be the attorney's client that they, many times they've known for years. They can see the client. They usually know the client. The witnesses are typically the attorney's paralegal or office assistant that are all, there either on the screen or in person. And that supervising attorney is tasked with making sure that if anything looks wrong, that they question it. They can not supervise. They don't just supervise, they certify. They have to do an actual certification that there are two credible witnesses. So it's not just any witness, it's a credible witness that is sitting there. They have to make a determination, like any time that whether the client is in person or on the screen, we really do need to make sure that that client is not under undue influence. We ask the right questions. If we feel uncomfortable, we don't move forward. So that's the reason we have that supervising attorney looking at the entire process. We have layers of protection. The issue that we're actually looking at today is not necessarily the propriety of electronic wills, which was actually passed last session when the Electronic Wills Act was put into law. We're just looking at the requirement of a notary. That's the only thing that we are actually focusing on today is, does the addition of a notary signing that self-proving affidavit give us any more protection? And we're arguing that it does not, because you already have a supervising attorney involved with the entire process. Sometimes that attorney is also the notary, but if they're not, you have to pull in a separate notary, and also the electronic notary requirement pulls it under Rolona. And right now we have to have these private vendors to provide electronic notarizations. So I think the real critical point is, does the notary, in addition to the supervising attorney and the two credible witnesses, add anything at all? And we are arguing that it does not. That's why we want to allow the self-proving affidavit to be signed by either the supervising attorney or the notary. And one other thing, it's a self-proving affidavit. That means that supervising attorney is really swearing that these people did sign in front of them. In not just in front of them, but they need to certify that the testator and the witnesses are looking at each other at the same time. Everyone is in the room or virtually looking at each other. So that's really all that we're talking about today, is does that additional element of a notary add anything?
Look, I was up front with you. I don't see a notary. I don't even care about this notary thing. It's irrelevant to me. A notary is no more reliable than a witness. I see how people get notaries in the state. Anybody can get one. They're given out like bubblegum wrappers. So it's not, not a big, I get no additional comfort out of, oh, there's a notary. My concern remains that look, if you have a major law firm, I'm almost more comfortable with this, but most people's wills aren't done by a major law firm. Most people's wills are done by a much smaller firm, and we have firms who specialize in quick wills. This will enable them to do relatively quick wills. You don't even have to come into my office. I can do 5 wills a day. You don't have to come to my office, and we can knock these puppies out. And you're all in your 60s, and by the time these things come up, I'm retired anyway. So you're not gonna be able to get a hold of me. There's no. I just find the lack of witnesses. Or the lack of a willingness to send for witnesses to go out. Witnesses are often nurses who are, if it's a person who really can't come in, they're frequently the nurses, people who can actually are there and attest to the persons that, yeah, she was there. I just gave her dinner. She seemed fine. She was happy and all that, or other kind of caretakers or neighbors, friends and neighbors that actually come in. I just haven't seen the challenges to do this. And by the law requiring people like that to come in and actually be present. Wow. Okay. I'm not going to belabor this one. I for one don't feel comfortable at all in having seen too many cases where will fraud was alleged. And we do have cases where we have a pandemic where the governor has to declare an emergency and we have to do emergencies. And I got that. And we did the right thing. I'm not disputing that. You got to get people wills, not have them die without a will. I was totally fine with that. But in the ordinary course, which we are now entering, I'm not following the need for this, but I'm all throw out this notary thing. Anyway, thank you all. Appreciate it.
Mr. Chair, if I could just interject one long sentence, and that is that the concerns raised by Senator Cassidy were raised last year in connection with last year's bill, which authorized remote execution of wills. This year's bill, that was passed last year. And so this year, the only thing this year's bill does is say that you do not have to have a notary in connection with the execution of a will, that a supervising attorney plus 2 other witnesses can take the place of the notary. And as Senator Cassidy has indicated, he doesn't care much about the notary one way or the other, and he's right on that. You can get a notary at a local drugstore. So this is much more of a technical bill, which has no substantive effect, unlike last year's bill, which had a serious substantive effect.
Excellent. Thank you, Senator Cassidy. Thank you, Senator West. All right, turn to the committee for additional questions. Seeing none, That will conclude the hearing for Senate Bill 36. We'll now move on to Senator West with Senate Bill 261. Senator West, you're up.
Thank you, Mr. Chair. This bill it really is just a technical bill. It's introduced by the business law section of the State Bar, but I think the Estates and Trust sections is in support of the bill. So let me first define what we're talking about. A limited liability company, otherwise known as an LLC, is a business entity set up by one or more persons who are referred to as members. A partnership is another business entity set up by one or more persons who are referred to as partners. Two different entities, very similar in so many ways, but they have their differences, which don't make any difference to this bill. Each member of the LLC has a membership interest. Each member of a partnership has a partnership interest. The members of the LLC generally execute an operating agreement, which details the roles and responsibilities of the members and provides for how the LLC will be run. The partners of a partnership generally enter into a partnership agreement, which does the same thing for the partnership. Another critical element of the operating agreement and the partnership agreement is a provision providing for the transfer of membership interests or partnership interests under various circumstances. This provision is especially important if one of the members of the LLC or one of the partners dies. Absent such a provision, the member's interest in the LLC or the partner's interest in the partnership would devolve to the estate of the member or the partner. And in that event, the disposition of the membership interest or the partnership interest would depend on the members or the partner's will. This would present a challenge for an LLC or a partnership because the LLC operating agreement or partnership rarely provides for the member's estate or the partner's estate to become a member or a partner of the LLC or the partnership, as the case may be. So most LLC operating agreements and most partnership operating agreements provide for the transfer of the membership interest or the partnership interest of a member or a partner who dies. That's the way it works. So we had a 2021 decision of the Maryland Court of Appeals dealing with an LLC. And it held that an operating agreement provision directing the transfer of a member's interest upon death was testamentary in nature and was not valid because the execution of the operating agreement was not accompanied by the usual formalities required in connection with the execution of a will. This decision, which is known as Potter versus Potter, creates huge uncertainties about the validity of disposition on death provisions of virtually every single LLC operating agreement. And I might add, virtually every single partnership agreement in the state. It threatens to wreak havoc with these agreements unless it's fixed. This bill is intended to fix the problem. This bill effectively overrides Potter versus Potter by providing that the members of an LLC and the partners of a partnership are free to agree among themselves on disposition of death provisions in the operating agreement or the partnership agreement. And it specifically states that a disposition upon death provision in an operating agreement or a partnership agreement is not testamentary in nature and therefore is not subject to the formalities required by Maryland law for the execution of a will. I support Senate Bill 261 with a minor technical amendment, which I will provide to the committee. And I think Ken Abel, who is a leading member of the state's business law, the State Bar Association's business law section, is here with us to further discuss the bill.
Excellent. Thank you very much, Senator West. And Mr. Abel, you're up first. We'll go with you. Welcome.
Thank you. Sorry, I wanted to make sure I was off mute. I think Senator West stole much of my thunder, so I will be brief. I'm here today in favor of Senate Bill 261 on behalf of the Maryland State Bar Association Business Law Section. before Potter was decided, most Maryland lawyers drafting LLC agreements and partnership agreements believed that we had the ability to draft those agreements as the members or our clients saw fit. And so, for example, if a couple of folks from the Estates and Trust group are going to testify after me, but if the three of us, John, Deb, and I, form a PR company, let's say, and we decide that if we're each going to provide services, and if one of us were to pass away, then the ownership of the company after I pass away, let's say, become 50-50 between John and Deb instead of the three of us, each a third. And we get a lawyer and we draft that up and we're all sort of operating on our way. And then I happen to pass away and they believe that they're going to continue operating. They're of course working in the business and they deserve the benefits of the business. Well, Potter says not so fast. The operating agreement that you signed with a lawyer, although I should note many people don't use lawyers to sign operating agreements. They use products like LegalZoom and other products like that. And those sorts of products would never know sort of the unique aspects of Potter. Potter's saying, sorry, Deb and John, you're now you have to give a third of the profits over to Ken's estate, even though that's not what the two of you thought the deal was, and it's not what Ken wanted. And so Potter would the legislation would basically reverse that decision, and it would apply both to LLCs and partnerships, and says if this sort of provision is in an operating agreement or a partnership agreement, then that provision, as Senator West said, would be non-testamentary and would be respected instead of the interest being devolved to my estate. Simply put, Potter creates a trap for the unwary, both experienced lawyers like me that draft these things all the time, general practitioners that do it occasionally, and frankly, just regular folks trying to pull a document off of the computer. Senate Bill 261 eliminates that trap for the unwary and essentially places the law back to where most of us thought it was before Potter was decided. And I'll turn it over to my colleagues, Jonathan Lasley and Deb Howe from the Estates and Trust Department. To start section, sorry about that.
Thank you very much, Mr. Abel. We'll now go on to Mr. Lasley and then over to Ms. Howe.
Actually, could Ms. Howe go first on this?
Of course.
Mr. Chair, thanks.
Thank you. And thank you to the committee for taking the time to hear us today. Ken focused on the business law section, and I am an Estates and Trust attorney. I'm a member of the Estates and Trust law section for the MSBA. I'm going to focus on the estate planning side of this. And I mean, full disclosure to the committee, I was involved in the Potter litigation representing a party in that matter. So this is a matter that's very close to my practice. The reality is that small businesses often decide to control the disposition of a business interest in the business documents rather than their estate planning documents. There are a number of reasons for that. One is privacy. Obviously, if this were controlled by a will, it would go through probate, which is not a private process. Another is efficiency and keeping the business matters kind of separate in a business on the business side rather than within the probate process can be very important to these families and small groups who have businesses together. But whatever the rationale is, the reality is that people often choose to do this. And Ken stated very clearly that existing documents, because of Potter, many, if not most existing partnership and operating agreements will have provisions that are no longer valid. And then future documents, especially for if they're prepared by attorneys who are not following the minutia of estates and trusts law, or general practitioners simply won't know to not include these provisions. They'll think that their clients are set and they'll be drafting provisions that are in fact not valid under Maryland law. This creates a real problem moving forward as these businesses will not have, the agreements that they make among themselves will not be valid and binding on their estates, which is an uncertainty and frankly, a messy business situation that we are eager to avoid with this legislation, which is why I'm asking for a favorable report on Senate Bill 261. Thank you.
Excellent. Thank you very much. All right, next we'll go with Mr. Leslie.
Thank you, Mr. Chair, members of the committee. I'm Jonathan Lastly. I'm a past chair of the Estate and Trust Law section of the Maryland State Bar Association, and I am here in support of Senate Bill 261. The solution to the problems that Ken and Deb have outlined in the bill is to specifically authorize the operating agreements of LLCs and partnership agreements to include transfer on death provisions, and to modify the Estates and Trusts article to add those agreements to the types of instruments that are deemed not testamentary. So they join in the specific list there, and there are others that are covered at common law, but the specific listed ones are financial transactions. So you've probably heard of TOD accounts for bank accounts, transfer on death accounts for bank accounts, or financial accounts, brokerage accounts. Similarly, the beneficiary designation on your retirement account is not testamentary in nature, even though it has that effect. And those things are specifically allowed under the code. This bill would overrule Potter by adding those provisions in and saying, no, this is going to restore where we all thought the law was. It's going to allow the members of businesses to enter into these agreements, and it's going to give the people on the estate planning side certainty that these agreements are going to work, so that they can plan the rest of their estate around the fact that that business is being disposed of pursuant to its agreement. So again, we urge a favorable report. I gather Senator West has a small amendment, but otherwise, that we hope you will move forward with it. Thank you.
Thank you very much. And with that, Senator West, that'll conclude the testimony for Senate Bill 261. Now turn to the committee for questions. I would say Senator Sidnor, go ahead.
Thank you. This as I'm trying to wrap my head around this, but I'm curious in looking at the State Bar Association's bill explanation on page 2, in talking about the example that's included. It says, if the LLC in the above example was created in New Jersey, but Mary moved to Maryland where she died, the valid New Jersey provision of the New Jersey LLC may fail to control Mary's LLC interest, which would instead pass to her estate under Maryland law. So this raises concerns for the LLC members who would like to move to Maryland. What I'm trying to understand, I'm assuming with the New Jersey LLC is created in New Jersey. How does, and again, I don't work in estates and trusts, so this is probably why I'm having this issue. But if the New Jersey LLC is a New Jersey instrumentality, wouldn't wouldn't one look to New Jersey law to figure out what the law is, or what it was intended under, rather than looking to Maryland law? And I guess this would go to Mr. Lastly.
So the answer would be, it depends on what New Jersey law is, but the logic of the Potter case, if moved forward and taken to its extreme, would say that if that instrument is not deemed testamentary under New Jersey law, then the Maryland requirement could kick in and say it's not testamentary here. So if there's a specific provision of New Jersey law that says, like the one we're proposing here, that says it's not testamentary, my personal opinion is that would govern. But the court's logic in this was such that they could say, no, if there's any ambiguity, we get to apply the Maryland law, and I'll defer to Ken and Deb if they have other opinions on that.
And most business documents, they're outside, I guess outside of Maryland now with this opinion, you can find they're looked at as testamentary. So I mean, one wouldn't be looked to probate and wills and things to figure out somebody.
No. Most are under contract. So most are contract. So people look at it and say, all right, I contracted with my partners to run a business, and part of that deal is that this is what's going to happen to my interest when I die.
And do you file that with the Register of Wills, like a will?
No, it's just a contractual arrangement. So if in my will, for example, I say, the agreement says the one thing is going to happen. If in my will I say something else is going to happen, so rather than give the interest to my partners, I'm going to give it to my child. My partners then will have a contract argument against my estate to force the correct operation of that agreement. And what this is saying is that what the Potter decision says is that contractual obligation is in effect void, because it wasn't deemed.
You should have put it in a will, is what they're saying.
Well, no, they're saying you should have had two witnesses and an attestation clause in the contract.
Like you required as if it was a will.
Exactly, like you would in a will.
Okay, thank you.
And currently you'd have to have a notary. If
it was remote, yes.
Cause to pass your other bill. There you go.
Thank you.
All right. Thank you, Senator Sidnor. We'll go to Senator Hedelman. Oops, sorry about that. Yep.
Thank you, Mr. Chairman. Just a quick question. What prompted this issue to go to the court in the first place? Was this an agreement that was contested by heirs of one of the parties? Is that how it ended up there? I guess Mr. Abel, and I think you're
actually Ms. Howe, I think would be the right one for that.
I'm sorry.
Thank you. Excellent question. It sort of a long story, but there was an operating agreement that said one thing and a spouse that said it should come to the estate and be inherited by her. And so we, litigated up to the Court of Special Appeals, which is what resulted in this opinion.
Okay. Thank you. And I think I did want to say, I think Mr. Abel, I think you're a constituent of mine. Is that
yes, and Senator Hedelman is my senator, so thank you for having me.
Thank you. Thanks.
You were well represented in the General Assembly and in JPR. There you go. All right. All right. Looking for additional questions. Seeing none, thank you very much, Senator West. And with that, that'll conclude the hearing for Senate Bill 261. We'll now move on to Senator Lee, our final bill of the day. Senator Lee with Senate Bill 265. Senator Lee, you are up. If I can find you. Here you are.
Okay, I think I finally got muted. Can everybody hear?
We can.
Okay. Thank you, Mr. Chairman. This is SB 265, probation, not deportation. This bill corrects a major inequity and a cruel unintended consequence in Maryland's current probation before judgment law that was never foreseen nor intended by our legislature when the law was originally passed. This bill is more nuanced version of a bill that passed our Senate in 2020, but failed to pass the House because of the 2020 session ending early due to COVID. This bill resolves the technical concerns that were raised in 2020. Probation before judgment was intended to be a means to balance the best interests of both the public and the defendant, yet alleviate the implications of finding of guilt for the first time by these offenders. It enables the defendant, which in many cases committed a first time minor nonviolent offense, to learn to take responsibility for their first time mistake and have the opportunity to lead a productive life and give back to their community without facing a lifelong consequence of a criminal conviction. In Maryland, a PBJ is not considered a conviction for state purposes. However, under the federal immigration law, it's considered a conviction, resulting in a legal conditional resident, a legal permanent resident, or a non-citizen being subjected to deportation once the PBJ is issued. You will hear today from our witnesses about some of the most heartbreaking cases, usually involving, this is a typical profile, an individual who, when they were very young, committed a minor youthful offense, nonviolent offense, and then they received the PBJ, and they were given a second chance to get on with their lives, serve with distinction in the United States Armed Forces, and become a really model employee, a small business owner, or a community leader, and is very often the sole breadwinner in their family, and they never again committed another offense, only to find that they're now subject to deportation, shattering their lives, separating them from wife or husband, or their children or their grandchildren, their friends and their colleagues. And so it's just a very devastating experience for them. Please consider Dorothy Stewart, who came to the United States as a legal permanent resident with her mother at 10 years of age. She later enlisted in the United States Army, and at 19 years old, faithfully served for 7 years after completing active duty in Korea and Germany. And she was honored with the Good Conduct Medal, the Army Service Ribbon, the Overseas Ribbon, and the Army Achievement Medal, and the NCO Professional Development Ribbon. Towards the end of her service, unfortunately, she was sexually assaulted. And to cope with that trauma, she started to use drugs and ended up with a PBJ for a conviction that made her deportable and prevented her from becoming a United States citizen. People like Dorothy deserve justice in Maryland. In Dorothy's own words, she said, "Today, I'm 61 years of age, still eager to become a citizen of the United States. It's been frustrating and extremely disheartening to live with this PBJ that's prevented me from becoming a citizen and moving forward with my life. It stripped my life away from me, as my life has been defined entirely by one charge that occurred 31 years ago." A PBJ, as it is currently written, does not account for first-time offenders, nonviolent crimes, or fair consequence that is disproportionate to the situation that gave rise to it. Probation before judgment is not supposed to be a finding of guilt by the plain and reading of the term of art. The General Assembly, they created probation before judgment for the same reason that I'm offering this bill. The current PBJ law unintentionally created unequal application for citizens and non-citizens. And this bill is largely a technical fix to achieve equal justice and a just and humane policy that aligns Maryland with other states. Other states have done this, such as Virginia, New York, and Pennsylvania, that have also passed legislation to fix their own PBJ laws. The bill does not disturb, erode, or replace the current method of obtaining a PBJ. It just simply allows the court to impose a probation in the absence of a guilty plea or a finding of guilt and enter into a probation agreement with the individual. Thereby, the court agrees not to make the finding of guilt as long as the individual successfully completes the probation. In exchange, the individual will waive their right to a trial in the event of a probation violation, the right to appeal the probation agreement. And if the probation is violated, the court can then revoke the probation and enter a deferred finding of guilt and sentence the individual for the underlying crime or an offense. I've worked very closely with the Maryland State's Attorney and the Office of the Attorney General, and we've all agreed to make an amendment, a technical amendment, and it is now available with our counsel if you want to review it now. The advocates and the stakeholders that you will hear from today will discuss the particular details of the provisions of the bill, as well as any concerns that were raised by the administrative office of the courts. But I'd like to, on bottom of my heart, thank State's Attorney Joe Riley and the other state's attorneys and the assistant state's attorneys, the Office of the Attorney General and the Office of the Public Defender, and retired Judge John Gossard and the American Civil Liberties Union, CASA, advocates immigrant rights, the community and faith leaders, and the Asian American Pacific Islander Caucus, Legislative Caucus of our General Assembly, and the other stakeholders for working together in good faith and in consensus to achieve a just, equitable, and humane solution, as other states have done, to address their inequities in their PBJ laws. So for those reasons, I request a favorable vote on SB 265 from my esteemed colleagues. Thank you, Mr. Chairman.
All right, thank you very much, Senator Lee. We'll now turn over to your panel, and we'll start off with Ms. Carl. Gabriella, good to see you. Welcome. Let's see if I can get you unmuted here. There you go.
I think I got it. Thank you, Senator Smith. Thank you, Senator Lee. My name is Gabriela Quercia Carl. I'm the Associate Director of the Chacon Center for Immigrant Justice at the Maryland Carey Law School. And we ask for a favorable report on SB 265 with the amendment, a bill which eliminates the unintended immigration consequences of Maryland's PBJ, as Senator Lee just explained. This bill proposes an equitable solution. Add an alternative process to Maryland's PBJ statute so that courts can find facts justifying a finding of guilt without requiring an admission of guilt from defendants that would trigger the federal immigration law. All aspects of this alternative PBJ comply with Maryland law. The same PBJ consequences will attach to the defendant. Those currently excluded from a PBJ will remain so. This bill does not replace current PBJ law, as Senator Lee explains. It adds to it. The bill before you today was developed in coalition with the Office of the Attorney General, state's attorneys, and other criminal and immigration law experts. This bill enjoys broad support from various organizations and government entities, as reflected in the sign-on letter we filed and in the witnesses you will hear from today. The only opposition is from the Maryland judiciary, which lays out concerns that are easily addressed. Our bill is consistent with Maryland rules, and the procedure the bill lays out was endorsed by federal Fourth Circuit law and is followed without any constitutional concerns in Virginia, New York, and Pennsylvania. There is broad recognition that this bill is necessary. It fills an important gap in Maryland law. All other dispositions are deemed convictions under federal immigration law. This bill also promotes racial justice. Because communities of color are often over-policed and prosecuted, Black and Brown people are more likely to face adverse and often severe immigration consequences as a result of low-level crimes where a PBJ is warranted. This bill will contribute to finality of judgments and judicial economy. It will eliminate the need for appeals and post-conviction proceedings to fix harmful PBJs because they will no longer exist. This bill is about fairness, equal treatment under the law for all Maryland residents, regardless of their citizenship status, no more and no less. We therefore urge a favorable report with amendment of SB 265. Thank you.
Excellent. Thank you very much. All right, we'll now move on to Mr. Davis. Andre, you're up. Welcome. Oh, see if we can get you unmuted here. There you go.
Mr. Chairman and distinguished senators, thank you very much for affording me this opportunity. I'm just so pleased to add my voice to the broad array of advocates and supporters and urge your favorable support and report of Senate Bill 265. It was Justice Brennan who made the insight that the equal treatment of those who are unequally situated is every bit as much a violation of equal protection as dissimilar treatment of those who are similarly treated. And this operation in tandem of Maryland law and federal law amounts to an equal protection violation, in my judgment, my respectful judgment. I'd invite you to engage in a thought experiment for a moment. I'm fairly sure no member of this committee and no member of the General Assembly would ever vote for a PBJ statute that said this disposition is available to citizens, but not available to non-citizens. People with green cards, people working, supporting their families, serving in the military, and on their way to citizenship. I don't think Maryland General Assembly would ever do that, but that's the effect of the combination of federal law and state law as things now operate. Now, it's an equal protection violation, but to be sure, it is not one that is cognizable that any person who is harmed by this confluence of federal and state law could ever bring a lawsuit or seek relief. So the relief that must be made available in the interest of equal protection of the law can only be granted by this General Assembly, and I urge your favorable report. If I can just use the last few seconds of my time to offer a couple of observations about the judicial conferences, government relations and public affairs, I guess, committee or task force. First, they seem to have a problem with a conflict between the bill and a rule. Well, forever, statutes have prevailed over any contrary rule. And if the General Assembly adopts this amendment as it should, then it may be that the judiciary will have to tweak one or two rules. But that's not a real problem here.
Time.
Second, the whole issue of finding facts is something that judges do all the time, and I don't think this bill creates a problem. Thank you very much for allowing me to offer my support.
So thank you very much, Judge, and we'll move on to our next witness, and that will be Ms. Alonso.
Hi, good afternoon, everyone. My name is Janice Alonso, and I urge a favorable report of Senate Bill 265. I'm a senior academic advisor and adjunct faculty at the Community College of Baltimore County, and also a doctoral student at Morgan State University. I've also been personally impacted by the injustices in Maryland's current PBJ statute. A close family member who has DACA received a DUI in 2020. After he went to court, his charge was a PBJ. He completed alcohol counseling classes even before his court hearing and is working on paying the fine incurred by the court. He made a mistake that night in 2020, but he's taken full responsibility for what happened. This family member is married and he has a small child. He also owns his own business, owns his own house, and pays taxes loyally every year. His child is the most important thing in his life. And every day we worry that the PBJ could lead to deportation and not seeing his child grow up every day. He takes his child to sports activities, indoor playgrounds, and more, and his child loves his daddy. This family member and the rest of our family treat every day as special in case his days in the US are numbered. We've cried and are very worried about the fact that this family member could be sent back home because of his one-night mistake. What happened almost a year and a half ago was a wake-up call for him, and things truly got better for all of us after he realized what he had done. The fact that a PBJ could break apart this family and cause a little boy to lose his father has been very stressful and heart-wrenching for all of us. The family could lose their home as he's the main income source, and his employees could also lose their jobs since they work for his company. The family member has been in the US for 17 years, and this is the only incident on his record. It would be unjust for a family to suffer unnecessarily because of the PBJ on this person's record. I'm pleading to our elected officials to pass Senate Bill 265 so that no one's subject to deportation because of a PBJ, and so that no family has to suffer like ours. Thank you.
Thank you very much, Ms. Alonso. We'll now move on to State's Attorney McCarthy. I see is here.
Good afternoon, Senator Smith. I am here in strong support of Senate Bill 265. I think that what this bill does is very humanely and intelligently tries to eliminate an unfair collateral consequence of a criminal proceeding here in Maryland. The irony is, I adopt almost everything that's been said by everybody that precedes me. But I think without this correction, we allow federal policy to frustrate Maryland law. We've made an intelligent decision here in Maryland that in appropriate cases, judges when they look at the interests of the defendant before them and the protection of the public, they can on balance render this decision and give this kind of a benefit to any defendant that comes before them. The federal policy undermines our policy, the decision our judiciary has made about the people that live in our community. For decades, we've engaged in making immigration-friendly pleas here in Montgomery County, where the consequences of a criminal matter outweigh the appropriate penalty for a particular crime. I think we have that situation here. I would urge you to eliminate this manifestly disproportionate consequence for those individuals who are affected by this. This is a very common sense. It's fair. If you're interested in justice, fairness should matter. This collateral consequence far outweighs. The example that was just given about the DWI, separating someone from their family, is a disproportionate penalty. We should never be in favor of a law that punishes people disproportionately based on their immigration status. Thank you very much.
Excellent. Thank you very much. All right. Next, we will go with Mr. Lichenbaum. You're up next.
Good afternoon, Chairman and committee members. My name is Jacob Lichtenbaum. I'm an immigration staff attorney at CASA, the largest membership-based immigrant advocacy organization in the Mid-Atlantic region, with more than 90,000 members in Maryland alone. My organization urges a favorable report for Senate Bill 265 because our members are routinely and significantly harmed by PBJ dispositions as the Maryland statute is currently structured. That Maryland PBJ is a conviction for federal immigration purposes deeply hurts our DACA clients, who are young people who entered the US unlawfully as children, who stand to receive protection from deportation and permission to work in the US. In order to qualify for DACA, a person must demonstrate, among other things, that they have not been convicted of a felony, a significant misdemeanor, or 3 or more other misdemeanors. To give you an example of the statute's impact, in 2018, a DACA client of ours named Ryan, his name changed for privacy purposes, which initially charged with first-degree assault, which was then amended to second-degree assault. That charge was then no prost. Ryan was pled to disorderly conduct, for which he received probation before judgment. By giving Brian probation before judgment, the judge was likely sparing him, and he was only 19 at the time, from receiving a criminal conviction upon completion of his probation. However, in the eyes of the federal immigration system, Brian has been convicted of disorderly conduct. This is a disposition he'll have to live with for the rest of his life, which could strip him of his DACA status and render him vulnerable to deportation. And so the minor but significant changes to the statute presented in this bill will allow CASA's DACA clients and other members to live freer, safer, and happier lives. Thank you very much for your time.
Thank you very much. All right, next we'll move on to Mr. Zavin. You're up. Welcome. Oh, there you go. Sorry about that. Here you go.
Good afternoon, Mr. Chairman, members of the committee. I'm Brian Zavin. I am the Chief Attorney of the Office of the Public Defender's Appellate Division. The Public Defender supports SB 265, which would provide a much-needed correction to Maryland's probation before judgment, or PBJ law. As it stands, the law does not work as intended. The General Assembly intended for PBJs to not operate as convictions, and we know this because the Criminal Procedure Article 6220 says it. The problem is that federal courts exploited a loophole to get around the prohibition on treating a PBJ as a conviction. The statute currently requires a PBJ to be preceded by a guilty finding in the form of a plea or a verdict. That guilty finding is equivalent for federal immigration purposes as a conviction. So an otherwise hardworking, law-abiding, tax-paying Maryland resident who had a minor mishap years ago that everyone agreed at the time should not be an impediment to them in the future can lose their right to be in the country. It's not an issue that could be easily fixed at the federal level, but it can be easily fixed here. And I say easily because it's not something that courts and lawyers will have difficulty putting into practice. As with PBJs currently, a court must first find that a PBJ is in the best interest of the defendant and the public. Second, the defendant consents in writing. Third, the defendant waives trial and appellate rights, which is done every day in court. Fourth, the court must find facts sufficient to make a finding of guilt, but defers entry of that finding. And fifth, the defendant agrees that in the event of a violation, the court may enter a guilty finding and impose sentence. The last thing I want to note is that the Senate bill does not otherwise alter existing law. If a defendant is not currently eligible for a PBJ because of the nature of the crime, the defendant remains ineligible. If the defendant is ineligible to receive a certain type of license because of a PBJ, the defendant remains ineligible under the revised law. It fixes what's broken under the current law, no more, no less. And I say that not to trivialize its importance, but to underscore it. For all the above reasons, the public defender urges a favorable report. Thank you.
Excellent. Thank you very much. All right, we'll now move on to Mr. Giannetti. Yeah. Good to see you.
Mute. Here we go. All right. Thank you very much, Mr. Chairman, members of the committee. Great to see you again. John Giannetti for the Maryland Criminal Defense Attorneys Association. This is a great bill. This is a really great bill. Some of you remember Joe Valerio, right? I was an attorney in Joe Valerio's law office. He gives me a file my first day of working for him. He says, come back with a PBJ or don't come back. And I didn't even know what a PBJ was. They didn't teach us that in law school. So what I tried to tell my clients, and listen, PBJs are a tool that are used by the defense bar, that are used by prosecutors to move cases along. Because if you can tell your client that you can plead guilty to something or have a nolo contendere plea and the case, and you're not going to have a punishment because you're going to have a probation before any judgment, then the client is typically going to say, yes, it gets rid of the need of a trial. The problem is this, with these cases that now we found out that they might have immigration issues or might even have a federal license issue, you're going to have to try that case. And it's going to bog down the courts. You know, PBJs happen, you know, tens of thousands of them every year. It's important that this is right. It seems that the bill has been nuanced and made better this year. The criminal defense attorneys are in favor of it. I'm glad that the prosecutors were working alongside, and it's a dynamite bill. I can give you more details if you have any questions.
Excellent. Thank you very much. All right, next we'll go on to Ms. Johansson.
Chair, Vice Chair, and committee members. My name is Emily Johansson, and I'm an attorney on the Maryland team of the Capital Area Immigrants' Rights Coalition. We urge a favorable report on SB 265, probation, not deportation. Our organization represents immigrants who are detained, and our client data shows the harmful impact the existing PBJ system has on immigrants in Maryland, particularly immigrants of color. 99% of CARE Coalition clients with a Maryland PBJ were Black or Brown. Of those, at least 53% were detained by ICE after having contact with the criminal system. These numbers exemplify the ways that our criminal legal system and its racial discrimination have long served as a direct funnel to the immigration legal system. Black and Brown immigrants are more likely to have encounters with law enforcement and to be charged and prosecuted for crimes which lead to deportation. While in detention, Black immigrants are 6 times more likely to be sent to solitary confinement. Overall, Black and Brown immigrants are more likely to be detained and deported. But the probation not deportation bill will help to reduce the detention and deportation of immigrants that are disproportionately harmed by the criminal legal system. This legislation is more important than ever in the context of our global pandemic and the high prevalence of COVID-19 in immigrant detention centers. SB 265 promotes racial equity, fairness, and safety for all Maryland residents. For these reasons, we respectfully request a favorable report. Thank you.
Excellent. Thank you very much. All right, next we will go on to Mr. Gossard. I can find you. There you go. Excellent. Mr. Gossard, you're up.
Can you hear me?
We can.
Okay. Thank you. Mr. Chairman, Senators, thank you for the opportunity to come and testify before you today. My name is John F. Gossard, Jr. I'm a retired United States immigration judge. I served on the bench for 31 years in Baltimore, Maryland. Justice and fundamental fairness requires that all Maryland residents be treated equally under the probation before judgment statute. Currently, it does not, with significant consequences to non-citizens. Today, I ask that you do the fair thing, the just thing, the right thing, and render a favorable report on Senate Bill 265 so that all Maryland residents will be treated the same with a probation before judgment disposition. I want to share with you a case that I heard, the case of Daryl, a lawful permanent resident of the United States, a green card holder, married to a United States citizen with 2 U.S. citizen children, a homeowner, a taxpayer, employed in the state of Maryland. Daryl was charged with a minor offense in Maryland, and like many first-time offenders and individuals charged with minor violations, he was accorded the opportunity to receive probation before judgment. But because Daryl was not a citizen of the United States, I in fact was forced to condemn him to the gravest of punishments, deportation under federal immigration law. It did not matter that Daryl had been deemed worthy of a second chance and had not been convicted under Maryland law. Daryl is one of hundreds of non-citizens who have been deported because of the Maryland probation before judgment statute as it is currently written, many of whom are permanent residents of the United States. This bill will ensure that the consequences of probation before judgment are the same for all Maryland residents, for citizens and non-citizens alike, narrowing the disparity in our criminal justice system and immigration systems which disproportionately affect people of color. I remember vividly the day that Daryl came into my courtroom, detained, in custody. His wife and his children, his in-laws and family and friends were there to testify on his behalf, to support his case, to ask for a second chance. The law did not permit me to give him a second chance. The rigidity of the law required that I order Daryl removed and deported from the United States. He was taken away and subsequently deported from this country. And his banishment is a banishment for life. His wife, Michelle, wrote me a letter after those proceedings, and she said, Judge Gossard, you are a powerful man. You have much authority, much discretion. You could have given my husband a second chance. You did not. May God forgive you because I cannot. Those were her words to me. That day, I did the right thing under the law. I did the correct decision, but it was not a just decision. It was not a fair decision. Banishment for life for probation before judgment in Maryland should not occur. I ask for a favorable report, and I thank you for your time.
Thank you very much. All right. Now we'll move that completes the testimony for the proponents of the bill. We'll now switch over to the folks that are favorable with amendments. And we'll start off with Mr. Riley. You're up.
Thank you, Chair Smith. Distinguished members of the Judicial Proceedings Committee, my name is Joe Riley. I am State's Attorney for Caroline County and the Legislative Chair for the Maryland States Attorneys Association. We are glad to report that we are supporting this bill with amendments. The amendments are two. They are the ones that were written and I believe provided to you by the Attorney General's office to help make it clear that this is to function as a probation before judgment as it is currently stated for Maryland purposes. And that's important for one particular reason. If a person receives a probation before a judgment for a second-degree assault, domestic violence related, they can't possess a firearm. So we wanted to make sure that that was clear if a probation before a judgment was granted in these cases in a domestic related incident, that person also would not be allowed to possess a firearm. So that's one part. The Second Amendment, and this is from previous versions of this bill over the years, is that the state was an agreeing party to this plea and this disposition, for lack of a better term. That's not present in this bill. We're suggesting that it be added, and for this reason. everyone here, we all are under the understanding that this is to help people who have immigration consequences. But the reality is you can't write that into a bill. So this is going to be a disposition, we're worried, in the state's attorney's realm, that everyone is going to want. So we're going to have fewer and fewer guilty pleas, and instead we're going to have people coming to the bench and pleading, Your Honor, we're pleading that there are facts justifying a finding of guilt. And so it'll act kind of like a nolo contendere type of plea. We encourage the state be allowed to enter into this agreement so we don't have more people taking advantage of this than aren't the intended people to take advantage of this. Right now, currently in my office, I can tell you in Caroline County, if the public defender or defense attorney comes to me and says, like one of the other examples, this is a disorderly conduct, can we put this on the STED or an active docket to avoid immigration consequences? We do that. So we have the conditions for a probation. Maybe there's a community service or fines to be paid for restitution or what have you. And there is no consequences. So we encourage those two amendments, but other than that, we support the bill and thank Senator Lee for bringing it forward.
Excellent. Thank you very much, Mr. Riley. We'll now go on to Ms. Garth. There you go.
Thank you. Good afternoon, Mr. Chair and members of the committee. My name is Jessica Garth, and I'm the Chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I'm here to show my support for Senate Bill 265 on behalf of State's Attorney Aisha Braveboy with the friendly amendment that's proposed, and that's regarding the domestically related cases. We would ask for a favorable report with that amendment. For many, the current probation before judgment statute has guaranteed a just result for victims while ensuring that criminal defendants can remain employed at a jail and able to get necessary treatment without adverse effects. However, this just result is not often available for non-U.S. citizens, or often not available for non-U.S. citizens, as the current statute requires an admission and a finding of guilt, which federal law deems a conviction and potentially leads to deportation. My office wholeheartedly supports this legislation's goal in expanding access to equal justice for all under the law, regardless of place of birth. We support with amendment because of our concern regarding individuals who are receiving a probation before judgment for crimes that are considered domestically related. And that's because this demarcation limits the ability of these offenders to own and possess firearms in the future, which we do feel is an important public safety consideration. The proposed friendly amendment, however, more than satisfies that concern, and that is why we do support this bill with that amendment. Equality under the law should be the same for all persons involved in the Maryland criminal justice system, and no one should have to face unintended penalties merely because of the location of their birth. We again urge a favorable report with the protections of the proposed amendment. Thank you.
Excellent. Thank you very much. All right, and now that completes the testimony for the proponents. We'll switch over to the opposition panel, and comprised of Mr. McAvoy. Is Mr. McAvoy here?
He is not here.
Excellent. Okay, with that, that'll conclude the testimony for this bill, for Senate Bill 265, and now we'll switch over to the committee for questions. Senator Sidnor has a question.
Thank you very much. Just so that I'm clear, I think Mr. McCarthy, he's testifying in support of the bill as it is. His organization, they're saying that they support with amendments which were noted in the Attorney General's letter, but and the Attorney General saying that they support, but the Maryland Judicial Conference is saying that the bill raises all sorts of due process concerns, but I'm assuming that the things that the court is raising as due process concerns have all been addressed by you all working together. And if I might direct this question to, let me think. Mr. Riley, since you're speaking on behalf of the MSAA, am I correct that everyone seems to be good and that the due process concerns have all been addressed that the court was talking about?
Senator Sidner, thank you for the question and the opportunity to speak. But I am not privy to the letter that you have from judiciary.
Okay.
I know that there have been throughout the years that this bill has come up, due process concerns, and we've worked with the Attorney General in the past, and the Attorney General has said that the amendments that they have added address their due process concerns. So without having the ability to see the letter that you have from judiciary, I really can't answer intelligently on that.
Okay, well, then if I might ask a similar question to my brother, Judge Davis, because I think in your testimony, you touched on the Maryland Judicial Conference's comments. In your humble opinion, are the things that they were talking about in this letter, they've been addressed?
They have, Senator. Thank you very much. And my opinion is humble. There is no due process concern that would bother any judge in Maryland in administering the statute as amended. As you know, defendants in criminal cases waive lots of rights all the time: the right to a jury trial, the right to a trial, the right to any number of things. And so there is no question in my mind that any and all due process concerns have been addressed.
Thank you. Because I note that Senator Lee was able to, not only does she have you on the panel and Judge Gosart, but also Judge Dornell, all supporting the bill, but it's just the state court's judicial conference that seems to be opposing this, which I find fascinating, that you all who really deal with this stuff, you're all supporting it. So I thank you for your testimony, and thanks Senator Lee for bringing the bill. Thank you.
And thank you very much, Senator Sidnor. We'll go to Senator Huff now.
Yeah, how are the amendments? I don't know what the amendments are, but the bill as it came in there, the judicial conference is pretty clear that you can't put people on a PBJ without you can't put people on probation without a finding of guilt. And so it's pretty laid out in the law. And so how do the amendments get around that?
Who would you like to direct the question to?
I guess maybe Mr. Riley, because he started to answer the previous one.
You're on the hot seat. There you go.
Senator Huff, I believe there was a company, I believe there was a written letter by the Attorney General, or at least by Carrie representing the Attorney General. Do you have that?
I'm looking through. I don't see it. And maybe Sandy, maybe it's forthcoming, but I don't see it in our packet yet.
Okay. And certainly forward the letter that I have from Ms. Williams I'm looking at now. Basically, the one amendment is in the waiver of right to appeal judgment of guilt. I believe that is on E3.
I guess just here's I'll make my question, I guess, simpler in that.
Sure.
And I'm not a lawyer here, but my understanding of the PBJ is that the court would have to enter basically there is a finding of guilt. There's and that's how you put somebody on probation. That you can't put people on probation unless you have that, or they plead no contest. And this would say, well, I guess the evidence is there to say they were guilty, but we're not putting a finding of guilt. Like how do you constitutionally put somebody on probation without a finding of guilt?
Senator, well, I understand that question, and that's something that has in the past, as if you recall on previous hearings I have been in opposition to this bill, that being one of the reasons. That's why in Caroline County, as I was saying in my testimony, we have a stay for these sorts of situations that avoids this problem. I am kind of relying on the letters and statements from the Attorney General that the amendments that they are proposing will allow for this again, I can't really say disposition because you can't be found guilty and still get the results that the advocates are looking for. So it's not really a disposition, but it is a plea. And this bill is kind of a exercise in faith, right? I mean, we're hoping that this result will work. Is what we're seeing. It's modeled.
I understand, but I mean, rather than pass a law, you can write a letter to the federal government and ask them to change their interpretation. You can have your members of Congress put in legislation to change their interpretation, but to go and completely change PBJ and saying, well, now I can get a PBJ and they're not being finding of guilt, everyone's going to want that. And then once I get that,
that is why
I can
we're
challenge the Constitution. And why wouldn't I go then challenge the constitutionality of my probation? You can't violate your probation. There's no finding of guilt. And
I think that question would be best directed to the public defender, whether they intend on appealing the.
I don't know. I'm shocked to see attorney associations in on this. The judiciary their letter rips this bill, rips it into shreds. And why are they in there? They're the only group that's not political. They just looked at the law. I mean, I would encourage all of you to look at the judiciary letter. It's pretty apparent where the problems lie in this. And there's dockets everywhere across the state.
So you've got, all right. Well, sorry, Senator Huff, go ahead. I'll let you finish your line.
I'm done.
All right. So I'd like, if we could, Ms. Carl, is that the judiciary says guilt, not guilty or a nolo. Can you just explain that through line, and then you can respond to Senator Huff's question?
Sure, I would be glad to explain to Senator Huff how this would work. And essentially what would happen is somebody would not enter a plea, and under the Maryland Rule 4-242B, when someone doesn't enter a plea, the clerk can enter a plea of not guilty. However, immediately thereafter, the state would propose the facts that could support a finding of guilt, and the court would make what is essentially a future finding of guilt should it become necessary that there are sufficient facts to conclude there has been a finding of guilt. So they're sort of pausing the finding of guilt, acknowledging that those facts do exist, and then the defendant waives all of their trial rights and agrees to enter into this probation agreement. So the person is not getting anything other than the failure to trigger the federal immigration statute that considers it a conviction. They're still under probation to the court. If they violate, they can be sentenced. If there is something attached to a PBJ, one of the amendments that we agreed to with the Maryland State Attorneys Association is that this PBJ is going to be treated exactly like the other PBJ. So it may be true that many people want this PBJ, but they're not going to be getting anything different.
That's with all due respect, that's not the law. We entered into an agreement with the association. What the Judicial Conference says, the amendments to criminal procedure 6-222 of the bill are confusing and are inconsistent with the requirements of Maryland rule, which you just cited, 4-242.
They were neglecting to consider Maryland rule 4-242B, and it's also
not guilty or nolo contendere. The court is not authorized to proceed disposition without taking a plea authorized by the rule. It is also unclear how a court would, quote, find facts justifying a finding of guilt, unquote, and how such a finding would fit into jurisprudential norms and safeguards. This bill is contradictory and also raises constitutional concerns. It goes on and on. I mean,
Senator Huff, I think that the judiciary here has not spent nearly as much time working on this bill and making it what it needs to be in order to understand the nuances of it. And the very rule that they cite to, Maryland Rule 4-242B, allows for no pleading to be entered. That being said, I want to refer to Judge Davis's earlier statement that rules really follow statutes, and routinely rules are changed to accommodate statutes. And I further want to note, Senator Huff, that there are other states who are doing this already, and that there's also been a Fourth Circuit case that talks about exactly this kind of procedure that is occurring in Virginia and found no trouble or constitutional issue with the way that this process
how many other
functions.
states have probation before judgment?
Countless other states, and the ones that are most analogous, Virginia, New York, and Pennsylvania. I believe also New Jersey as well. I'd also like to turn it over to my colleague, Mr. Zabin, who himself is an expert in criminal law, to address some of your concerns, because I can assure you that we took this all very seriously, and we're not trying to add a benefit or give anyone a way out. We have no interest in that. We want to be safe living in Maryland just as anybody else does. But what we're trying to accomplish is fairness under the law. And right now, as also Judge Davis helped us understand with his thought experiment, nobody would vote to pass legislation that only citizens could benefit from. No one on this assembly. And so therefore, it becomes critical that we fix this, because federal law is trying to thwart.
No, I mean, but I would say people would pass bills, including people in this committee, to add collateral consequences, PBJs, which comes in every year, and people in this committee, people in the General Assembly, have routinely added collateral consequences. In fact, because of the finding of guilt that you all are upset with. The exact amendment that you are proposing about gun ownership is a collateral consequence.
And that will certainly attach to anyone who gets this form of.
But that is a collateral consequence that politically that you're making a decision you're okay with, but you're not okay with the other one. With all due respect, there are a number of collateral consequences the General Assembly likes to add to these. And then you're more confusing the law, saying, well, it's not guilty, but then we're going to, on the other hand, add all these collateral consequences. It's just, I would agree with the judiciary. I don't think this makes good legal sense.
All right, Senator Huffy, you done?
Yep.
Good to go? All right, excellent. All right, I wanted, maybe someone can clear this up with me. Is this, so one, I think I'm just having trouble understanding, you know, you get the guilty, the not guilty, you've got the NOLO, but then like a NOLO is not an admission of guilt. Like, so I'm trying to figure this out. It's because it's the federal law clause that in, or how does that work? Because it's not like an Alford plea. It's like, it's something different. So I'm trying to think, I'm struggling to understand.
Senator Smith, logically, one would think that a nolo contendere would not be a conviction under federal immigration law, but it's written into the language of the definition of a federal conviction. A nolo contendere is considered a conviction. So that is the reason why it doesn't work.
That's why I'm trying to figure out. I'm like, I don't get that. Okay, excellent. Thank you very much. Mr. Giannetti, I'm going to chime in on the line of questioning that if it's responsive to what Senator Huff was asking.
Thank you very much, Mr. Chairman. Yeah, Senator Huff, I think what it comes down to is that the fact that, you know, I wasn't present when they created the PBJ law, and I'm sure that the judiciary was uncomfortable with the PBJ law when we first, when the legislature first said that this is what we're going to have, because what they've done is they've created a legal fiction. The PBJ in general is a legal fiction, and nobody really wants to face that fact, because what they do is the court hears facts and finds guilt, then strikes the guilty finding to give probation before judgment. So they, when someone finds guilt, that's a judgment, but they give probation before judgment, even though they're doing it after the judgment. And in Maryland, that seems to be satisfied, and we all sort of sit around and say, okay, this is a very important tool, so we're going to sort of forget that it is a legal fiction for a moment. Well, the federal government doesn't have to sort of drink the Kool-Aid, and they're saying that under the facts, if the guilt was found, as it was in a Maryland court, then that person is guilty under federal law. And so other states that have similar type of structures for their probation before judgment, like Virginia, like Pennsylvania, had to come up with a, you know, dealing with that collateral issue. And really, Senator Huff, I think that there will be other, you know, these amendments are for the committee. I'm not going to weigh in on the amendments. They seem to be, they seem to make sense, but I haven't looked at the implications of them. But the idea is that in Maryland, a PBJ is supposed to be used for someone who deserves to have it. There's no judge that has to give a PBJ in any court in anywhere, and we're not forcing the judge to do anything that they don't want to do. If they don't want to give a PBJ, then don't use this. Don't give them a PBJ. But what happens is, as Judge Davis sort of alluded to, a person can give up their right to search and seizure. A person give up your right to have a trial, all these important rights. Well, you can give up your right to the due process also by entering into an agreement in the court. You can give up your constitutional rights. We all should feel comfortable with that. And that's what this bill does. It allows the judge to find, you know what, there are facts here that could lead me to find guilt, but I'm not going to find guilt because I know that it has these collateral consequences for immigration. And if the lawyer's not going to ask the judge for it, then you don't have to go down that line. But this is a very important exception or nuance to make to this law that we have created, this legal fiction that some people still are not comfortable with. Thank you.
That was helpful. Thank you very much. All right, we'll go with Senator Castley.
Thank you. I guess maybe to Mr. Giannetti. I mean, probation before judgment, you use the term legal fiction, but at least it satisfies the due process clause of the Constitution. And that's what the Court of Appeals is concerned about here, that even if you're going to enter something that you would call a legal fiction, it still has to satisfy due process. And that's the court's concern, is that you're not satisfying fundamental due process. That's how they raise it. So how do you address that? I mean, I just don't see any merit to your position that, oh, this is a legal fiction. I mean, everything we do in the law is in some ways a legal fiction. It's all man-made. So we're not dealing with science here. We're dealing with the law. We make it, so we can make it what we want. But we are constrained by the U.S. Constitution. And it really appears to me that what we're trying to do is, in an effort to address tough cases, we're going to basically turn the Constitution on its head. And the real solution here obviously lies at the federal level. It's not the state of Maryland supposed to just call balls and strikes and follow the Constitution. And what we're trying to do is, in an effort to subvert federal law, that we're going to basically ignore the Constitution. How do you respond to that?
Well, I think, and Senator Castley, I do appreciate your looking into this. I think, I understand that your concerns are valid. However, I think that it's clear, all these rights, the due process rights, come from a document, and we all know the document. It's the Constitution, right? We all have constitutional rights. We have said, and it happens every day in courts, in your jurisdiction, and you practice, this, an individual can give up some of his most important constitutional rights. He can give up his right to trial. He can give his right to testify against himself, and that's what he or she is doing when they're entering in an Alford plea in Maryland, or a guilty plea, or nolo contendere, or other pleas. So realize you can give up your due process right is also a right that's conferred by that same document. All right, if it serves the purposes of the defendant, who has a lawyer in almost every certain circumstance, and the prosecutor and the judge all agree that this is what the result of this will be, they will allow that individual to waive their due process rights in the same way that they waive their other rights.
But even when you waive those due process rights, you have to be before the court. There has to have been a finding of guilt. The defendant has to understand that they have a right to a trial and to go forward. But there's still, the way you come before the court is that there's a case, and that unless the court finds you guilty, they have no jurisdiction over you. And we're saying just for the judge to do anything, judges have no standing to do anything without saying, oh yes, there has been a violation. Now, Mr. Defendant, we can proceed with a full trial, or you can say that's not necessary, and I don't need to bring a jury in here. I don't need to call witnesses because, in fact, I am guilty, and you can proceed. But at least the court, in order for the court to say there's a case, that the judge's ability to even stand there or sit there and do anything requires that there be a case, and that they do have a finding of guilt. You can delay that, set it, whatever you want, But how do you, this says, well, we're not even going to go that far. And I think that's the problem in the courthouse. We're sort of ignoring things like standing. I mean, the court can't waive standing. They can't waive, I mean, there's certain things that you can't waive that provide the court with jurisdiction. You can never waive jurisdiction. We have certain basic things that say this court has the authority to rule here. And we're standing one of those. I'm just troubled because as we try to get around these issues and try to circumvent the federal law, we sort of creating these, I think we're doing long lasting and serious damage to the Constitution of Maryland and to the law of Maryland. That the rulings that we make, the things that we do now, will not just carry into this issue. I mean, once you let the genie out of the bottle, it's going to be there. It's in our law, and it wouldn't just apply to this particular aspect of it. It would apply to all of law, and that gets somewhat concerning for our rights in general as citizens of the state and of the country. I'm just troubled by that. I mean, I certainly, you have really compelling cases here, and this is all, I don't want to destroy families. I don't want to, all that stuff. But, in the interest of the Constitution, we send our sons and daughters off to foreign lands and have them killed. It's really dramatic. We have police officers go out and be shot down in cold blood over the last couple of days. That's all in the interest of defending the Constitution. So we do take certain stands that say at some point we do put the Constitution above our conveniences, even our own comfort and our emotions. We put the Constitution above that, and it seems like we're reversing that and saying, yeah, but it is just a piece of paper, and when it's not our convenience, let's ignore these fundamental principles that have made us the most amazing country in the history of the world. This is scary to me. Thank you.
May I respond, or is that?
Sure. Yeah, please.
Thank you, Senator. And listen, all due respect, and everything that you've said, I agree with philosophically. I understand exactly where you're coming from, and I would say that if I were in your shoes, that it's clear that you take your role very seriously. And what I would say is that, in the separation of powers, the legislature often does things that the judiciary isn't comfortable with. And, we have conferred upon our judges a great deal of discretion. And, that's why the process of becoming a judge in the state of Maryland is not easy. Once they're on the bench, there's not a single judge that's going to be, their arm is going to be twisted to do this. They will have the ultimate discretion as to whether or not they take advantage of this new probation before judgment that has these provisions to them that we're changing. What we have is we have 50 different states in this great nation of ours that all have come up with different solutions to different problems, and a federal judiciary that has been given power to look at state issues and determine whether or not state issues violate federal provisions of the law. So that's what we have here. We have, found that certain states, including Virginia, that was really the motivation for this bill, I understand, was, Virginia had the same problem that Maryland did, and it wasn't an intended consequence. We expected that judges that gave a PBJ in Maryland that they weren't going to have, they weren't going to be deported under DACA or any other federal statute. The federal statutes change every year. They increase, there's federal regulations. And so in order to fix that, Virginia came up with a certain scheme, meaning a certain wording that seemed under the Fourth Circuit to address the issue that was intended in Maryland, and that's not to have any consequences, to allow that person to continue on as a member of society. Now, again, yes, your initial point was certainly there are things that the defendant can't waive. The court does have the power, even before they call anyone guilty. The court has the ability to force you to show up before you're found guilty. You don't show up, you could be arrested. All right, so the court does have powers before they have guilty, and what they're saying is we're all going to agree that the court will have this power under the agreement of all the parties, and we're going to have a signed agreement that if I find that the facts would justify a finding of guilt, you're going to put yourself under the auspices of this court while you go and do the rest of these things, which we currently call probation, but it's going to be called a probation under this new scheme. So yes, a defendant who is the one that owns the right to due process. It's that individual. He can waive or she can waive that right in order to get the result that they're looking for, in order so it won't have those immigration consequences. I don't think, I think it's tricky and it's nuanced and it may be a little upsetting, but it's what's necessary to address these problems, because we can't change the federal law.
I've seen in other contexts where judges who don't agree with certain penalties in the law simply find the defendant not guilty. As a defense attorneys often have their clients do a lot of things before trial, so that the judge, that you go through training, you do public service, you run through 100 hours before the trial. So when you get there, the judge sees, oh my gosh, this person is certainly showing contrition, and they just go ahead and find them not guilty because they realize they've already assumed the punishment anyway. So there's lots of things that we do to facilitate that. But the sort of the light way we're treating, legal fiction, to me, the constitutions of the country and the state either mean something or they don't. And people have died to say they do mean things, and that just seems like we're treating that rather lightly here. Thank you.
Thank you.
So thank you, Senator Castley. We're going to go to Senator West. Has his hand up. Senator West, go ahead. So let's go ahead and unmute. There you go.
There we go. Okay. Thank you, Mr. Chair. A really brief question, and it's for the sponsor of the bill. The Maryland Judicial Conference's memorandum refers to an Attorney General's opinion dating from last March. I vaguely recall having read that last March because we had a bill similar to this last year. Could you obtain that Attorney General's opinion and provide copies of it to the members of the committee?
I can do that. I can make sure we do that.
Okay, great. That's my question. Thanks.
Excellent question. All right. I do want to give, just because the conversation has been, I think, enlightening. So I'd like to, Mr. Zabin, you had your hand up. I'd like you to, it's direct response to kind of the colloquy that was going between Senator Castley and Mr. Giannetti. You go ahead and chime in, and then Judge Davis, I want to grab you as well.
Yep. Thanks so much, Chairman Smith. I think we need to distinguish between the court's power to put someone on probation before judgment and the court's power ultimately to impose a sentence in the event of a violation of probation. And I think that's where this bill is very carefully tailored to work on. So here you have an agreement between the defendant and the court to enter into this probation agreement, which the defendant agrees will not be appealable at that point. The question is, what can the court do in the event of a violation? This is where the General Assembly had passed something similar to this a number of years ago, and it ran into trouble because it didn't give any clarification in that area. What happened was there was a violation of probation, and then the court just imposed sentence in that case. And the Maryland court said, whoa, you can't do that. That violates due process. That's a problem. And this bill takes care of that, because now the defendant has agreed that in the event of a violation of probation, there will be the ability of the court to enter that guilty finding at that time. And that is the basis for the court's ability to impose a sentence. I mean, Senators Hoff and Castley, I mean, I certainly am every day fighting for the constitutional rights of my clients. The Constitution is important to me as it is to you, I think, and to my clients. I don't see a constitutional provision that's being violated by this. Frankly, I don't see any due process concerns with this. The defendant is going through a knowing and voluntary waiver of trial and appellate rights, which is something we do every day in court. The defendant is agreeing to go on probation. And in the event of a violation of probation, there's going to be a guilty finding entered at that time, which enables the court to impose a sentence. That takes care of all the due process concerns. The Attorney General had due process concerns last year. The Attorney General has since taken that position back based upon the way the law is constructed now. And the court, citing to the Attorney General's position last year, simply doesn't fly anymore, because that's not the Attorney General's position anymore based upon their careful review of the bill.
Thank you for that. All right, we do Judge Davis the last word here.
Thank you so much, Mr. Chairman. and Mr. Gavin got it exactly right. If I could respectfully, very briefly, help reframe this discussion. When a defendant represented by counsel stands before the court with notice of the charge, with the opportunity to make choices about whether to testify, whether to take a jury trial if one is available under the law, whether to call witnesses on the defendant's behalf, that is the essence of due process. That is due process on steroids. And so, as has been explained, what this amendment does to the PBJ statute is it makes it unnecessary for the non-citizen to admit guilt. That is the problem. The judicial memorandum seems to have a problem with this idea of sufficient facts to find guilt, but judges do that every day in all kinds of contexts. There's nothing weird or outside of the realm of judicial norms about a judge making a determination that certain facts are sufficient. And by the way, imagine there will be occasions, if this bill is adopted, when a prosecutor will stand before a judge and everybody's agreed to this disposition, and a prosecutor will stand before a judge and recite the facts supporting the crime. And some judge on occasion is going to say to the prosecutor, you have left out an element. Your factual statement supporting this crime is insufficient. And therefore, the defendant is actually not guilty based on these facts. Now, most of the time, that's not going to happen. The judge is going to say, I find that the facts not disputed here, not admitted, but not disputed, the facts in this record are sufficient for the court to find beyond a reasonable doubt guilt. But the court's not going to make that entry of guilt today. Rather, consistent with due process, everybody enters into the agreement for probation. And if the defendant violates probation, then the defendant comes back before the court and, having waived any objection to anything, is now subject to sentencing as an initial matter. And by the way, the memorandum really confuses violations of probation with conviction of a crime. Conviction of a crime will certainly constitute a violation of probation, but not all violations of probations are criminal convictions or even criminal acts. So this bill fixes all of that. And I appreciate, Mr. Chairman, this opportunity, as I say, to respectfully reframe the discussion. This is due process. This is due process on the hoof. This is due process, quintessential due process. Thank you.
Well framed. Thank you very much for that. All right, Senator Carter, you have a question. I see your hand is up. Go ahead.
Thanks, Mr. Chair. So I've been listening to the back and forth and the robust discussion, and I appreciate the discussion about this issue. But I thought maybe 15 minutes ago and still asked the same question of Mr. Giannetti or Judge Davis, whoever would like to answer. So I keep thinking that we're getting stuck a little bit on words, on nomenclature and what we're calling something, because I think that a similar result to what we hope for here could be achieved with a not guilty agreed statement of facts and a judge holding it could not. Why are you shaking you're shaking why can't I wasn't finished, but so in a not guilty agreed statement of facts, the facts aren't being disputed, but the person is admitting to nothing. And then the judge deciding, as Judge Davis just talked about, holding this decision until after the person has had a chance to complete some stuff. That reminds me of holding the the disposition sub curia. So how is this different than a not guilty agreed statement of facts followed by a sub curia disposition? Person gets the complete stuff.
So Judge Davis.
There's no finding of guilt ever if the person successfully completes the stuff on the sub curia disposition.
Thank you so much, Senator. Actually, Judge Battaglia wrote a wonderful opinion some years ago that really explains the differences and similarities between not guilty statement of facts, agreed statement of facts, Alfred pleas, nolo contendres. Federal law treats not guilty statement of facts or agreed statement of facts as the defendant admitting to the facts. And as Gabe mentioned, federal law explicitly includes nolo contendere in the list of kinds of dispositions that are treated as convictions. So under the case law in the federal courts, not guilty agreed statement of facts is treated exactly like a guilty
plea
or a guilty plea. Yes, ma'am.
Thank you.
Still doesn't make sense. Yeah, you're right. All right.
Well, I think, well, correct me if I'm wrong, isn't not guilty agreed statement of facts another legal fiction that we created in Maryland? I don't know if this is prevalent anywhere else. Yeah.
All right, excellent. We'll end with that. Unless any members of the committee have additional questions. Or Senator Carter, if you have additional questions, you're good to go. All right, excellent. All right, that'll conclude the hearing for Senate Bill 265 in our hearings today. Thank you very much. This is an enlightening discussion, so it's a good way to end the day. Thank you all very much. Have a good one.